Okay. This is the execution case. This was filed before my lordship, motion for such. But as because that is not the arbitration matter, that was why the matter was released from her list and the matter has been transferred to my lordship court. Oh, my this but we have applied. I'm for Bank of Baroda. Applied for the withdrawal of this execution case, and my lordship for that
So you decree
to be appeared in the list for the listing the matter.
You are appearing on behalf of decree holder.
Yeah, my lordship.
Yes.
The Bank of Baroda.
So include করতে বলছি please.
Original site commercial division, item number 1.
My lord, this is my execution application. By my lord's last order, my lord had directed us to file an application.
Which for the judgment data?
My lord, they had entered appearance. No. Commercial division. My lord, we kindly take one order, my lord, passed by my lord's predecessor, 5th April 2023. They had entered appearance.
Just a minute.
My lord.
The learned counsel for the decree 6 to submit a comprehensive application before this court in the meantime.
My lord. My lord, may I just
for an accommodation.
My lord, may I just indicate, my lord, this is a execution case filed against a partnership firm. My lord, it had fell from my lord that perhaps we require to add the partners specifically as parties because in the execution case, my lord, only the firm is party.
No.
So we had taken out that application. It's been taken out. The master summons has already been taken out. It is returnable on 23rd. My lord, we've dispatched it for service. My lord can keep that application on the list, my lord, 2 weeks hence, so that it can be served and it can be heard out. If my lord pleases, my lord, apart from that, one submission may I just make, my lord. This is in relation of a decree passed against the partnership firm. The partners of the partnership firm have already entered appearance before my lord. 5th April 2023 is recorded. They appeared. They undertake to file their wakalatnama. Therefore, my lord, I would have humbly prayed for my lord directions for them for a warrant of arrest to be issued against them since they haven't filed their affidavit of assets. But my lord, we've taken out of abundant caution, we've taken out an application to add them as parties.
The learned counsel for the decree holder has submitted that the decree holder has taken steps to add the partners of the partnership firm against whom the decree was passed for abundant precaution. Stop. For completing all the formalities, he needs some time. Stop. Please the matter after 2 weeks.
Obliged.
4th March. Item number 2.
Pass over.
Item number 3.
Pray for a short passover by I'm being led by Mr. Rajshri Datta in this matter, Your Lordship. He's on his way, he's on legs, Your
Okay.
Just a short passover, Your Lordship.
Okay, pass over.
Item number 4.
But I am appealing for the judgment data, my lord. The decree holder is supposed to file the affidavit in reply to them, my lord.
Okay.
Not aware, my lord. It was wrong.
Sorry. Yes, pass over. এই আগে ওটা একটু দেখে কোনো লাভ হবে না, এটা করে দাও। আচ্ছা আগে আছে না, কটার সময় আছে ওটা? একটার সময়, কিন্তু ওরা যদি এখন চলে আসে, দেখুন যত তাড়াতাড়ি পারেন করে একটা, আর একটু আগে যদি পারেন। হ্যাঁ, ঠিক আছে। এটাই করবে না পরে?
না কমার্শিয়ালে থাকুক, পাস ওভার হয়ে
চলে যাবো।
হ্যাঁ। Original side matter. Execution cases item number 1.
My lord, I appear for the decree holder. My lord, I would only humbly beseech your lordship to let the matter to stand over for a fortnight. The reason being, my lord, they have preferred an appeal challenging the decree passed by this honorable court.
The learned counsel for the decree holder has submitted that the judgment debtor has preferred an appeal, and as such, the instant matter should be adjourned for at least 2 weeks. Any stay order?
Yes, your lordship, there's a stay going on.
No, there is no order of stay.
Then
Just a moment, your lordship.
No, my lord, these submissions, my lord, I am taking exception. There is no order of stay.
Your lordship, I'm not aware.
allow her to speak,
Yes,
then
ma'am.
you will speak.
Your lordship, not.
Yes.
Yes, your lordship. Just give us. I am not
Hey,
aware whether
Kushi.
there's a stay or not, your
গরম
lordship.
করছে কেন? গরম না? হ্যাঁ? হুম। সময় হয়নি? দরজাটা খুলে দিতে হবে। Yes,
My
madam.
lord, may I hand over the last order
Last
passed by the
minute.
appeal court?
Yes.
Your lordship, if my learned friend has the last order, then it would be very helpful.
Have you got the order of stay?
Your lordship, I am not aware of it. Your lordship, I've not
Please
got
the
the
matter after
instructions.
2 weeks. হয়ে গেছে তো?
2 weeks. 4th March.
ওই ফার্স্টের কথাগুলো লিখেছেন তো?
Item number 2.
Two, my lord, I am for the decree holder, my lord. But by an order dated 30th November, my lord has already partially satisfied the degree, that is vacant position of the room. My lord, there was another part of the degree, my lord, obtained the mean profits, and my lord, it amounted to 18 lakhs. My lord, I am filing a supplementary affidavit. My lord, according to the lease agreement that was entered into between the parties, my lord, the rate of monthly salary that has to be given to us, my lord, that will increase by 20%, my lord. My lord, as of today, the dues would be 59 lakhs 88,000. My lord, previously on 2nd February, when the matter was taken up, my lord had passed an order for attachment of the bank account.
Yes.
My lord, we have given letter. My lord, in the bank account, there is a mere sum of, my lord, 4,000 rupees. My lord,
What can I do now?
I am praying for order in terms of prayer D and E of the tabular statement. D and E.
What is a prayer for D and E? You file an affidavit.
Yes, my lord, I am filing the supplementary affidavit, my lord.
You have stated that only 4,000 is there.
No, not my lord. That I do not know, my lord. That they have
Then-
to come. My lord. But
then-
the bank official has told me that there is only 4,000.
And you have to made such amendments in your affidavit.
But
because-
that I will file a separate supplementary affidavit
Then
and
they
give, my
come
lord.
back with all.
My lord, kindly take this supplementary affidavit on record, my lord.
Okay, I'm taking, but it is not complete. The learned counsel for the decree holder has submitted one affidavit, one supplementary affidavit. Let it be taken on record. Stop. After going through the supplementary affidavit, it appears that the same is incomplete since
No, my lord, this supplementary affidavit
I am
is
giving
regarding
direction.
the increase in the dues, my lord. That only for that purpose.
Let it be taken on record. ওইখানে বলে রেখে দিন. Stop. The learned counsel for the decree holder has further submitted that he wants to file another supplementary affidavit intimating this court that the attached bank account has only 4,000 rupees
Or approx would be
approximate কথা লিখে দিন. Stop. And as such, আর কি as such বলতে হবে না. Stop. Please the matter after
1
3
week,
days,
my lord. 1 week.
1 week. After 1 week.
Deep level, my lord.
Appeal 26.
26.
এটা কত হলো? 2 হলো.
Item number 3 and 4.
My lord, I appear for the decree holder. On the last occasion, your lordship had passed an order directing to file affidavit of assets.
I'm filing this. Then I'm also.
So I have to consider and come back after a fortnight. Let me consider.
Fortnight,
Or
Why?
a week? No,
1 week.
1 week, yes.
The learned counsel for the judgment debtor has submitted affidavit of assets of the judgment debtor. Judgment debtor company.
My lord.
Yes.
Stop. Let it be taken on record. Stop. The learned counsel for the decree holder has sought for an accommodation for coming back with proper instruction.
Yes.
Stop. List the matter after 1 week.
Deep level.
It's also connected. Same number.
4 is also connected, same.
Yes, action legal.
Then 4. Grateful man.
Item number 5.
Lordship, I beg to appear on behalf of the decree holder, Lordship. Pursuant the last occasion,
Decree should come here in this time. Yes.
Lordship, on the last occasion, Lordship directed us to file an affidavit in respect to that there is no appeal pending against this decree, and there is no stay order staying this decree, Lordship. Lordship, my
When the decree was passed,
Lordship, in this decree is Lordship on Lordship, just a minute. Lordship, your Lordship has already passed an order. Receiver has been appointed, Lordship, and receiver have already taken the symbolic position, but not the 6th October 2016.
yes, and directed to submit an affidavit stating that no appeal is pending against the relevant judgment and decree, or no stay order has been granted
Yes, Lordship.
by any higher forum. Have you submitted?
Yes, Lordship.
What is the contention of that affidavit? Please read out
Lordship.
that you have stated.
Lordship, I am reading from the beginning. From the paragraph 2, Lordship, that I say that the judgment and decree dated 6th October 2016 16 passed by the 5th Joint Civil Judge Senior Division Nagpur in the special CS 476 of 2013, the suit property and the same is awaiting for execution. I say that the said decree dated 6th October 2006 is still unsatisfied and the same is liable to be executed. I say that the decree holder has not arrived at or agreed to any settlement, compromise or arrangement with the judgment debtor in respect to the decretal claim. I say that to the best of my knowledge, no appeal against the judgment and decree dated 6th October 2000 passed by the learned 5th Joint Civil Judge Senior Division at Nagpur in the special CS number 476 of 2013 in the above suit has yet been filed by the judgment debtor. I say that there is no order of stay of the judgment and decree dated 6th October 2016 passed by the learned 5th Joint Civil Judge Senior Division at Nagpur in special CS 476.
So this is transmitted. This decree is transmitted for execution.
Lordship.
Okay.
This is transferred, Lordship, initially it was filed before the Nagpur court, Lordship, and it was found that all the property lying over at Calcutta, Lordship, then it was transferred before your Lordship, and we moved that, Lordship. We have served them on several occasions. Affidavit of service has been filed before your Lordship, and with satisfying with that, Lordship, your Lordship has passed order in respect to my application. And receiver has been appointed. Receiver went to the place, Lordship, taken the file also report on the last occasion, Lordship. So on the last occasion, your Lordship I was praying before your Lordship to pass an order in respect to that, take the physical possession of the property, Lordship, as mentioned in the application, your Lordship, and then your Lordship was pleased to direct us to file the affidavit stating this, Lordship.
Have you received the your remuneration? Yes. What is now your prayer?
Lordship, that may kindly, Lordship, give a direction the receiver to Lordship take the physical possession of the Lordship property, Lordship.
Yes. Tell me.
Lastly, I have filed my report, a short report, my lord.
Report ta dekhi.
The partner of the judgment debtor is not present at the time of my visitation.
Judgment debtor?
Not present at the time of the partner.
Have you received any communication from them that they have filed any appeal or anything? They did not
Communicated their staff through their staff phone. Say, I have received your notice, but I could not appear. I could not come today.
What is the decree about?
Amount, Lordship.
Decree above. What is the decree? What is the decree?
Lordship, this is an
Eviction, it is not an eviction decree.
no, Lordship, this is a money suit.
So there must be,
Money decree, Lordship.
yes, money decree.
Yes, Lordship.
So the property should be attached.
Yes, Lordship.
Then, hey, we pray at the decree. You are praying for in terms of have they disclosed any bank account to you? Have they disclosed any bank account to you? What is the prayer for taking physical possession?
That Lordship, that specific prayer is not there, but
Then
Lordship,
you are asking for an order.
Lordship, that my last prayer, that such other further order or order directed
No,
as
no.
this honorable court may deem fit and
How
proper.
can it be? It is not a decree for eviction. It is not a decree
No,
for eviction.
This is not
You can pray for attachment. But
Lordship, attachment also, Lordship, may have
so
done that.
you file an appropriate application before me. I cannot go through the last prayer. There's such further order or other orders, directions. How can I know what is your prayer? The higher court will find that this is my desire that physical possession may be taken. Come back with proper instruction. It's a money decree, I think.
Lordship, money decree.
Yes. Injunction restraining the judgment debtor from operating any of its bank account without keeping a minimum balance equivalent to sum of rupees. Is this prayer allowed?
Lordship.
When?
No, Lordship, that was not Lordship. Your Lordship.
Because you did not give the bank.
No, I
bank
have given
account
the
details.
property details. That is allowed, Lordship. That is the last occasion.
But physical possession cannot be taken. That order of attachment is there. You come back with proper instruction, okay? Your prayer is not clear. I cannot direct unless there is some specific prayer to that effect. And that prayer should be made in accordance with law. Okay? Shall I adjourn?
Lordship,
If you permit me, I shall adjourn.
Lordship.
Okay. The learned counsel for the decree holder has submitted that the learned receiver has already taken symbolic possession of the premises where Messrs. Balaji Exports has been carrying out its business. Stop. The learned counsel for the decree holder has prayed for a direction upon the learned receiver to take physical possession of the said premises. Stop. The learned receiver is present and she has submitted that she has already filed a short report. Stop. It appears from the submission of the learned counsel of the decree holder that this is a money decree. Stop. However, there is no prayer in the tabular statement that any relief has been prayed for obtaining physical possession of the premises concerned. Stop. The learned counsel for the decree holder has sought for an accommodation for coming back with proper instruction. When?
Lordship, after 2 weeks, Lordship.
2 weeks? 1 week? Or 2 weeks?
Lordship, actually, it's outstation client so that he get to come to a
Is the matter after 2 weeks?
grateful, Lordship.
4th March.
Grateful, Lord.
Item number 6.
This is my application. It is an execution application against the official trustee. They were to take instructions and come back before your lordship.
They
For
did
that-
not appear.
They are not-
Pass over.
Item number 7.
Item number 7, your lordship, I am for the petitioner decree holder. This is my execution application where I have received a decree in my favor under chapter 13A of the original side rules. On the last occasion, the judgment debtor was afforded an opportunity to file their affidavit in opposition to my execution application, which they have done. We have already filed an affidavit in reply. It is on record. On the last occasion, Mr. Dashgupta, who is leading me in the matter, he had commented submissions and he had indicated the points that the judgment debtor has assailed this decree on 2 grounds. Firstly, that the property is a Thika property, and secondly, on the point of pecuniary jurisdiction. So my learned senior had submitted that both these points had been taken before the trial court, and the decree also reflects the finding of the court on these 2 points. So today it is fixed for submission of the judgment debtor.
He is not here.
Not here.
So pass over.
Pass over.
এখানে যেমন এক্সামিনেশনের আগে তুমি ওই লিস্টটাকে আবার পেবে, তাই না? আচ্ছা, আচ্ছা, আটক দিকে
Item number 8. Pass over. চলো কমার্শিয়াল ডিভিশনে চলে যাও।
Lordship, item number 8, I am appearing for the decree holder. With Lordship's kind leave, I am appearing online because I am suffering from viral fever. Lordship, in this matter, the judgment debtor has taken out an application under section 47 of the code. Lordship, that is appearing as GA1 in Lordship's list. Affidavit in opposition has already been filed, Lordship. On the last occasion, I think a prayer was supposed to be made by the judgment debtor for filing of reply. If Lordship so pleases, Lordship may extend the time and fix the matter for hearing.
judgment debtor is not here. So
Lordship. Lordship.
পাস ওভার করো।
পাস ওভার। এবার কমার্শিয়াল ডিভিশনে যাও। Item number 2 for pass over matter, commercial division. Item number 2.
Your Lordship, I appear on the decree holder. On the last occasion, we had sought for an accommodation to file the assets and particulars of assets of the judgment debtor. Your Lordship, we have appointed an independent agency. I am humbly praying for some more time. File my report.
For the decree holder is present and has sought for an accommodation for filing report as per order dated 21st December 2023. Stop. When? This the matter?
Your Lordship, I am humbly praying for 2 weeks.
This the matter after 2 weeks.
4-3
Date দিয়ে দেবেন।
4-3 নাম দিয়ে যান। Item number 3.
My lord, I appear for the decree holder. Lordship was kind enough to give me 2 weeks time, my lord, to see, my lord, what steps, my lord, we can take. Cost not provided in the decree, whether I am entitled to.
Lordship had recorded in Lordship's last order that 2 weeks, my lord, as last chance would be given. My lord, may I hand over, my lord, a copy of the order? My lord, we have preferred. Own order. We have preferred an application, my lord, before the learned trial court, seeking recall of part of the, my lord, judgment by which the summary judgment application was disposed of, to the extent that the suit was disposed of and the reliefs with regard to interest and cost was not considered. In that application, a point of maintainability was raised by my learned friend, and affidavits have been directed to be, my lord, exchanged. Affidavits have not yet been filed, my lord. It is, my lord, due to be listed next on 19th of March 2024. I was only praying, my lord, since we have taken steps, my lord, to have that, my lord, decree, my lord, part.
The law, whether this decree will be merged with that decree.
My lord, if there is, my lord, I can file a separate execution. To be very
Yes, that is
candid, I can file a separate execution.
Otherwise, it will.
And my lord, or my lord, I can amend this execution, incorporate that as a relief, if at all, my lord, the court grants me that relief.
Withdraw.
My lord, I leave it to your lordship. My lord, I don't have instructions to withdraw. Lordship passes whatever order lordship feels, my lord.
No, I can.
My lord, my prayer is to defer it. My prayer is to defer.
He is not agreeing with.
My lord, if he is not agreeable, lordship will pass order, my lord.
I have.
Digital amount has been paid. They have failed to show any authority that the in execution proceeding in their degree their claim can go beyond the
what is their claim? Cost.
Claim for cost.
No, interest and cost.
Interest.
My lord, what trial court did was, trial court, while deciding the order 13A application, disposed of the application along with the suit.
Yes.
So, my lord, my application was in respect of the claim to which there was no defense.
Yes.
Apart from that claim, my lord, there was also a claim on account of interest and a claim on account of cost. Now, since the trial court, my lord, not only disposed of the...
It is the basic principles of law. Even if the prayer is not allowed, or has not been stated anything about that prayer.
Refused. Deemed refusal. But precisely the reason I have gone to the trial court seeking recall of that part of the judgment. That is the reason why I have applied.
I should not allow this. You have the liberty to file.
I leave it to your lordship. I will not persuade your lordship to, my lord.
The learned counsel for the judgment data.
My prayer is, my lordship may defer it after till 19th of March.
No. The decree holder, the learned counsel for the decree holder has submitted that his client has already filed appropriate application before the trial court for recalling the part of the judgment and decree passed on 8th December 2022 in connection with CS stroke 133 stroke 2019 along with other prayers. Stop. As such, he has prayed for deferring the hearing of the instant execution proceeding for 2 weeks. Stop. Para. The learned counsel for the judgment debtor has raised strong objection. According to him, the decretal amount has already been paid in full. Stop. There is no whisper. There is no whisper in the decree regarding the interest and cost as claimed by the decree holder. Stop. Para. I have gone through the entire materials on record. It appears that the trial court did not say anything about the relief of interest and cost as claimed by the decree holder. Stop. As the executing court cannot go behind the decree, I do not think the prayer for adjournment submitted by the learned counsel of the decree holder has any legal basis. Stop. Para. The instant execution proceeding stands dismissed. Stop. However, the decree holder is at liberty to execute any fresh decree in accordance with law.
Grateful,
My
man.
lord, one thing, my lord.
Yes.
My lord, that the degree has been, degree amount has been paid upon satisfaction of the.
I have
the court.
Lordship has recorded.
I have
It's
recorded.
recorded in a
And
previous order.
Degree is to be discharged. That degree which has been in awarded, that to be discharged.
Degree cannot be discharged. It is only satisfied.
The learned counsel বলিস না একটা the learned counsel has submitted আচ্ছা ওইখানটা তো বললাম তো আবার কি
Upon
in full
satisfaction
in
of the
full
court,
stop
that is to be
stop
recorded.
এটা একটা লিখে দিন, the decree has been satisfied এটা লিখুন therefore the decree has been satisfied decree has been satisfied on full satisfaction.
Yes. Whatever was the degree, I have received that.
Decree has been satisfied on full satisfaction এটা লিখে রাখুন একটা জায়গায় লিখে দেবেন ঠিক আছে stands dismissed হয়ে গেল তো
Decree has been satisfied in full. That should be, my lord.
I have already recorded
Yes.
ঠিক আছে satisfied in full করে has been
Grateful,
satisfied in full এই কথাটা লিখে রাখবেন ঠিক আছে আমার জন্য বললাম আপনি disposal হয়ে গেল
Item number 4, but I pay for the decree holder. My lord.
For the judgment letter, your lordship looks at the last order. Matter was adjourned on their prayer that they wanted to file a reply to my exception. I've taken exception to the receiver's report, taking possession.
But I'm
Saying
file.
that some of the assets have not been taken note of, which will satisfy their monetary part, which they are claiming. Your lordship, since they have filed their reply 1 week back, we are at a delay because your lordship, the advocate record, our advocate record was ill, we could not take any steps. Your lordship will kindly adjourn the matter for some time, we will file a rejoinder to their reply.
you have filed
But I've served them. I'm filing it
They
in.
have served.
the learned counsel for the decree holder submits the affidavit in reply. Stop. Copy has already been served to the judgment debtor. Stop. Let it be taken on record. Stop. Para. The learned counsel for the judgment debtor, number 1, has sought for an accommodation for coming back with proper instruction. Within 48 hours is sufficient.
No, sure, I will like to file a rejoinder to their reply. That is what the
Then
advocate
file.
told me, that certain factual allegations have been made, that has to be dealt with. The lordship will give me some time.
This is the matter after 1 week.
26.
এই যে
26 তারিখ না? আচ্ছা, 26 হলো না? চলো ওদিকে পাস ওভারে এটা কমপ্লিট হলো। 6 করো। Original side matter, passover matter, item number 6.
My application. Lordship, the official trustee was to execute a deed of transfer. Lordship, the decree has been passed. Lordship, we have placed the details of the properties they wanted to verify. They were here just now. They were here.
Yeah.
They are there. They are there. They just walked out. They are there. Lordship, the schedule has been corrected. The porchas have been handed over, showing the documents which.
So I shall ask the AGOT. I shall ask the AGOT to execute the deed.
Lordship,
Or Registrar General.
Lordship, my learned friend.
Original site.
My learned friend is here.
Yes.
Yes, but I have been favored with one copy, my lord, of this record of right. These dogs, my lord, this is a revised schedule they have provided, and my lord, the dogs which I have my lord, I have found, these dogs are tallying with the record of right they have given, excepting, my lord, in item number 2, my lord, 6721. একটু দেখুন তো আছে 6721 is only thing I am unable to find, my lord. Otherwise, my lord, the rest of the dogs, my lord, are tallying with the record of right. আসলে স্যার করতে পারেনি কেন আমাকে, আমি যেটা ছবি তুলে দিয়েছেন এটাতে এত ইলিজিবল পড়তে পারছিলাম, আমি আপনার কপিটাই নিয়ে আমি দেখছিলাম।
So only one property or several properties?
Lordship, there are several different dark numbers are involved, including various.
6,721. Apart from 6,721, all properties are okay.
Lordship,
According
all
to-
I think
So, apart from 6,21, I am directing. In case of 6,721, come back with proper instruction if necessary.
Lordship, I believe even 6721 has been given at a schedule 2.
Schedule 2.
6721 because the format আগের দিন যেটা দিয়েছিলেন স্যার ওটাতে 6721 নেই because the record of right which was handed over on the earlier occasion there also I could not find 6721 so if that is there then no difficulty because
So it is dark number or Kotiya number?
dark number
Dark number. The
Kotiya
flaw.
number is telling so 4174
Then
4174
Lordship, the dark number is also correct. I will.
Yes, hand over.
71 পেয়েছেন
6721 আছে
তাহলে তো ওকে
Here. 6721.
আমার কাছে নেই আমার কাছে 6718 পেয়েছে
6721. This is the area that we have sent. এইটা আমি চেঞ্জ করে দিয়েছিলাম এই যে 0.020. It has been changed 6721.
তার নাম্বার হচ্ছে 4174 এখান থেকে পাচ্ছি একটা কপি দিই then I think more or less the ducks are telling
Tell it. So I have to pass necessary order. Hey, give tabular statement. So I think your prayer has been in the tabular statement, I think.
Yes, my lord.
Absolutely. Yes. What is the prayer?
follow the execution of the deed of asset
Lordship,
That's
prayer A, your lordship will find the official.
Prayer A.
Official will be directed to transfer the land.
The schedule will not be the same.
the schedule there will be a
That's
change in
why
the
I'm asking. Whether this schedule
is the older schedule.
Oh no, I am giving you time. How much time you will require?
Milord, your lordship will direct that they convey in accordance with the draft deed that we have sent.
What draft? There.
Lordship, a draft deed has been sent and the schedule, amended schedule has also been sent to them.
in the
But my record?
Lordship, your record. needs
You
to
are
be changed.
very experienced and you are saying that I'm the junior most judge of this court.
Oh, my lord, we will.
Yes,
we
you
will,
know.
We will give a change.
What would be about this official record?
well, that has to be corrected
Lordship,
records
we will change it. We will change.
So how much time you need?
Lordship will
2 days.
for the
Milord, we will furnish your lordship with a correct copy of the schedule. If I want to amend it, it will take a long time.
Why?
Or if your lordship directs,
Unless this is corrected, I cannot pass any decree.
I quite agree with your lordship.
Yes.
Then your lordship give me leave to correct this schedule and we will do it.
supplementary affidavit করে যদি আমরা বলি
No supplementary affidavit.
I will correct it.
The learned counsel for the judgment debtor has submitted that the clarification regarding schedule of land have been correctly made from the side of the decree holder, and he has no objection if the learned court passes necessary order directing the judgment debtor AGOT to execute execute the deed of what?
Transfer.
Deed of transfer as per revised schedule. Stop. Para. The learned counsel for the decree holder is also present. Stop. Para. After going through the tabular statement, it appears that revised schedule of land is not tallying with the schedule annexed schedule annexed with the tabular statement. Stop. Para. The learned counsel, the learned senior counsel for the decree holder has sought for an accommodation for correcting or amending the
Lord, if your lordship says amending, that your lordship will
correcting.
correcting.
Amending correcting the schedule as mentioned in the tabular statement
In course of the day.
in course of the day. When we will fix?
Tomorrow your lordship can.
Yes. List the matter. List the matter. কালকে লিস্টে দিয়ে দাও. Okay. In the course of day. In course of day.
স্ক্যান করে নিচ্ছি আমাকে তো
কিছু হচ্ছে.
Lordship has granted us liberty to correct.
Your AGOD has been transferred.
an order has been passed by.
It's very well.
That is the problem, my lord. I don't know what will happen to the museum.
He is doing very well. However, you should execute this deed. Before he,
That's the reason why I'll also expedite because
No,
before
your lordship will kindly also set a deadline within which the document has.
come back on tomorrow. Your revised schedule is required to be incorporated.
Yes, yes.
No, I'll also advise my client to do it before his release
Yes,
order
yes.
comes in the event that.
Okay.
I'm grateful.
We are about to pass the order, but revised schedule and should tell you the. Okay.
So we'll have it corrected in the course of the day.
The difficulty will be the museum. The artifacts he has collected for the
Yes,
museum.
yes.
Real difficulty. I don't know how will things will now proceed with it.
কারেকশন এখানেই হবে ওটাই করব এটা কারেকশন করব করে রেখে দাও আইটেম নাম্বার 7 এখনো নেই
এই দেখি কি আছে রেকর্ডটা.
Lordship, I appear for the decree holder. The judgment debtor was supposed to make his submissions.
It is in respect of. Oh, he's here.
My decree for recovery of vacant and khas possession.
He is here. Okay.
Hello, may I pray for a short Passover? Could I come back at 2 p.m. subject to your lordship's convenience? My advocate on record is not here. He has some judgments which I seek to place reliance on.
Okay. এই দুটোর সময় কি আছে? হ্যাঁ. If you come back in the second half.
Very well, I will.
2
Okay.
p.m. Very well,
Grateful.
Lord.
I'm grateful.
But there are some examination of judgment debtors.
I'll wait, sir.
Okay.
I'm grateful.
2 p.m. করে রাখো. হ্যাঁ.
করে রাখবো হ্যাঁ 500 বারই থাকবে তো PM item number 8
Lordship, in item 8, I am appearing for the decree holder. The judgment debtor has filed an application under section 47. My opposition is already before my lord and also served on the other side. No reply has been forthcoming yet. I understand, Lordship, that no one is appearing for the judgment debtor before my lord today.
The learned counsel for the decree holder has submitted that he has already filed the affidavit in reply as per dated 7 February 2024 in connection with the affidavit in opposition.
Opposition, my lord. It is a section 47 application by the judgment debtor. My opposition is before my lord. It's been recorded in my lord's earlier order.
এটা কেটে দাও, কেটে দাও. They have filed the affidavit in reply.
No, Lordship. On the last occasion, they had sought time to file their reply. No reply has been served. Possibly they will take an extension, Lordship. I am not aware.
The learned counsel for the decree holder is present and has submitted that the judgment debtor on earlier date has sought for an accommodation for filing affidavit in reply, but today they did not turn up. Stop. Para. None appears on behalf of the judgment debtor even in the second call. List the matter. কালকে কত তারিখ?
20
আচ্ছা, এটা লিস্ট for ends of justice The matter stands adjourned. কালকে কত তারিখ হচ্ছে বলতো? 21 তারিখে দেওয়া। List the matter on 21st.
I'm obliged, my lord.
For hearing, item number 9 and 10.
Again.
My lord, already placed the facts before your lordship.
Yes.
Regarding the two properties, 88 by 2, Rafi Ahmed Kidwai Road, and
Use the microphone, please.
regarding lordship, I have already placed the facts before your lordship.
Note আছে তো।
Master.
সব 12টায়। তা 22 তারিখটা না আমার ছেলের পরীক্ষা, যদিও আমি চলে আসবো তাড়াতাড়ি, 5-10 মিনিট দেরি হতে পারে, নাও হতে পারে। Yes.
Lordship, on the last occasion, I have already submitted the facts before your lordship. Lordship, I now pray your lordship will take up this notice of summons, which master summons, which my learned friend was referring to the other day. Master summons.
Master summons. Yes.
Lordship, based on the facts that I have submitted before your lordship, my prayer before your lordship.
এই ওই মাইক্রোফোনটা কাজ করছে না নাকি?
I don't think so.
No, বন্ধ হয়ে গেল। হ্যাঁ।
No.
Lordship, my prayer before your lordship is A, master summons.
Yes.
Direct that the compromise decree having been passed on the basis of a conditional will and conditions not having been carried out or fulfilled by the original parties to the suit is ab initio bad in law and hence unhonest. Direct that the terms of settlement was an act of collusion and connivance between the original parties to the civil suit to circumvent and or to sidestep the liability to earmark a portion of the property at 88 by 2A Rafi Ahmed Kidwai for the purpose of setting up of the Jyoti Samrat estate, a trust to be established for the purpose specified therein. Direct the plaintiffs respondent number 1 and 2 being the successors in interest to the original plaintiff to file a statement of accounts of the rent proceeds collected from the tenants on the basis of the letter of atonement, which was obtained from the original defendant number 1, predecessor in interest of the applicants and the pro forma defendants herein, being the portion allocated for the purpose of establishing and the management of the Jyoti Samrat estate. Lordship, in the alternative, direct that since the compromise decree, Lordship, in the alternate praise that are in the alternative, since an appeal has been carried forward from this honorable court's order, Lordship, the alternate praise I personally believe should be praise which I should be agitating before the appeal court. Before your lordship, I would be agitating these three praise. And of
Only
course,
three. A to C.
A to C. And of course, your lordship, the G. I will be the pass such for the orders that the praise I would be praying before your lordship. Lordship, keeping this in mind, lordship, in the affidavit in opposition, first question, your lordship, whether your lordship exercising jurisdiction under section 47 of the Code of Civil Procedure can entertain my application, the one which I have placed before yourself. Can your lordship entertain that application, especially in view of the fact that the final judgment has been passed and an appeal has been carried forward? Lordship, that was a question which also your lordship, at the initiation of the case, it was also troubling me. Should I move an application here? Should I move elsewhere? So, Lordship, with a lot of responsibility, I advise my clients that we should move an application here. Lordship, may I place the Code of Civil Procedure? Raj? Court has held that admitted under section 47.
Application under section 47, no?
47. Section 47 reads, questions to be determined by the court executing the decree.
Yes.
All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Lordship, I would be laying emphasis on the fact all questions that arise between the parties or their representatives. Lordship, I am one of the representative of the original party. And this is a question, Your Lordship, which goes to the root of the decree and relating to the execution, discharge of the decree. Lordship, whether a decree exists or does not exist has to be decided by Your Lordship in under section 47. Then Your Lordship will come where a question arises as to whether any person is or is not the representative of such a party. I will not trouble Your Lordship. So all questions relating to the delivery of possession and of such property to such purchaser or his representatives shall be deemed to be questions relating to the execution, discharge, or satisfaction of the decree. So, Lordship, I would be emphasizing on the question, on the word all. All questions that arise between the parties. Lordship, this is a very pertinent question which is arising between the parties. Whether the southwest portion of the property was at all bequeathed to my
trust,
was bequeathed to my to us, to the family. Did the testator actually bequeath his entire property to his three sons? Or did he categorize his three sons into two separate categories? The trustees, the executors, the trustees, and the legatees. In my humble submission, Your Lordship, the three sons of the testator, they were acting as executors to the property. So they had to first execute the will. And what remained, as was so specifically stated in paragraph 6 of the will, what remained, and he has very categorically defined what remains, that was bequeathed to his three sons. Lordship, may I place a few judgments before Your Lordship? When I am praying, Your Lordship, that a fraud has been committed on court, Lordship will kindly remember, I am not praying that a fraud has been committed inter the parties. Because inter the parties, Your Lordship, there was a wonderful understanding before the decree was passed.
But you have received the fruits of decree.
Lordship,
and
I
then
may
you have
have
come back.
I may have. But what if the decree is, Lordship, what if there is
You have
no
accepted
decree?
the decree. Then come.
Lordship, please.
You have come back.
Lordship, family members.
These questions is troubling me also.
Lordship, it is also troubling me. I'll come to that.
You have,
Lordship, when family members get together
after receiving 10 lakhs.
and they enjoy the fruits, and thereafter, Your Lordship, it is found that the fruit never remained with them. It never belonged to them. Your Lordship will take away the fruit, whatever remains. Because, Your Lordship, I am before an executing court. I am only praying that the decree which was obtained on the basis of the terms of settlement, that decree is bad ab initio, is void ab initio. It was obtained by fraud and by misleading this honorable court. Lordship, I will be referring to this judgment, 2023 Supreme Court cases online.
2023
Supreme Court cases online. Page 1395. May I hand over a copy to your Lordship?
1395. SCC online. Supreme Court.
Lordship, I'm giving my learned friends a copy.
13. Yes.
Lordship, paragraph 9. Lordship, here is a suit which ultimately resulted in a consent. Lordship, the other paragraphs are very short. May I place it? Paragraph 3, your Lordship. The appellant is the landlord and the respondents are the tenants in the premises. Will also be referring to them as this. The landlord, who is more than 70 years of age as of now, had filed a suit for eviction which ultimately resulted in a consent decree on 11/6/2005, where inter alia it was stipulated that in case the judgment debtors fail to pay the rent for 2 consecutive months, they should be evicted as the decree would become liable for execution. Now, the question which came up before this honorable court was that consent obtained legally? Lordship, now I come to your Lordship to paragraph 9. Section 47 of the CPC reads as under. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Where a question arises as to whether any person is or is not a representative of a party, such question shall, for the purpose of this section, be determined by the court. Lordship, I'll take your Lordship to paragraph 10, because paragraph 9 is setting aside, has quoted section 47. Paragraph 10, a bare perusal of the aforesaid provision shows that all questions between the parties can be decided by the executing court. But the important aspect to remember is these questions are limited to the execution of the decree. The executing court can never go behind the decree. Under section 47 CPC, the executing court cannot examine the validity or the order of the court which had allowed the execution of the decree unless the court's order itself is without jurisdiction. More importantly, this order was never challenged by the tenants or judgment debtors before any forum. The multiple stages a civil suit invariably has to go through before it reaches its finality is to ensure that any error in law is cured by the revisional court, cured by the higher court. The appellate court, the second appellate court, and the revisional court do not have the same powers as the powers of the executing court, which are very extremely limited. This was explained by the court in Durandar Prasad Singh. It had stated as thus. The exercise of powers under section 47 of the code is microscopic and lies in a very narrow inspection hole. Thus, it is plain that the executing court can allow objection under section 47 of the code to the executability of the decree if it is found that the same is void ab initio and a nullity, apart from the ground that the decree is not capable of being of execution under law, either because the same was passed in ignorance or such a provision of law, or the law was promulgated making the decree inexecutable. So, Lordship, this is the law, that the executing court can go into the issue whether the decree itself is ab initio bad in law. Lordship, while passing this judgment, Lordship, the court was very aware that the limitation that the executing court is jurisdiction of the executing court is extremely limited. And while holding it is extremely limited, your Lordship, they have come to the conclusion that where it is found that the same is void, ab initio, and a nullity, the court can go into it. May I place paragraph 13? The reality is that pure civil matters take a long time to be decided, and regretfully, it does not end with a decision, as execution of a decree is an entirely new phase in the long life of civil litigation. The inordinate delay which is universally caused throughout India in the execution of a decree has been a cause of concern with this court for several years. In Rahul so-and-so, it is held is not a fact which being misused to cause injustice by preventing timely implementation of the orders and execution of decrees. Your Lordship, this was also an issue which troubled the Supreme Court, the delay, which, Your Lordship, is an issue also before Your Lordship, that the suit was in 2015, F5. The decree was passed, and now I am before Your Lordship after practically 10 years. Lordship, I'll take Your Lordship paragraph 14. There is a the above judgment is an important judgment in respect of section 47 as well as order 21. As a three-judge bench decision of this court not only condemned the abuse of process done in the garb of exercise of powers under section 47, but also gave certain directions to be followed by the civil courts in the exercise of powers in the execution of a decree. It further directed all the high courts to update and amend their rules relating to the execution of decrees so that the decrees are executed in a timely manner. As far as section 47 is concerned, this court has stated as under. Your Lordship, again an exception made. In respect of execution of a decree, section 47 CPC contemplates adjudication of a limited nature of issues relating to execution, discharge, or satisfaction of the decree, and is aligned with the consequential provisions of Order 21. Section 47 is intended to prevent multiplicity of suits. It simply lays down the procedure and the form whereby the court reaches a decision. For the applicability of this section, two essential requisites have to be kept in mind. Firstly, the question must be one arising between the parties, and secondly, the disputes relate to the execution, discharge, or satisfaction of the decree. Your Lordship, then these provisions contemplate that for execution of decrees, executing court must not go beyond the decree. However, there is a steady rise of proceedings akin to a retrial at the time of execution causing failure. I will not trouble Your Lordship. Lordship will come to the next page, paragraph 15. The court has then gave certain directions which were to be mandatorily followed by all courts. The court exercising jurisdiction under section 47 or under order 21 must not issue notice on the application of a third party claiming rights in a mechanical manner. The court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise would have been raised and determined during adjudication of suit if due diligence was exercised. So, Lordship, this is also a question of res judicata has been gone into in this court. Lordship, how has the court held, decided the question of res judicata? Lordship will kindly come to paragraph 20. As we have already referred above, this order was taken in revision by the judgment debtors, where the revision was allowed and the order date as such was set aside. The decree holder moved a petition before the Bombay High Court under Article 226 of the Constitution of India, and the main ground taken before the High Court was that the revision court fell into an error in holding that the application moved by the judgment debtors for setting aside the order date as such comes within the purview of the power of the executing court given to it under section 47. It was submitted by the decree holder before the High Court that the order dated such had obtained finality and res judicata would apply against the judgment debtors. In support of his submission, the decree holder relied upon a decision of this court where the court reiterated the settled principle of law that the principle of res judicata are not only applicable in respect of separate proceedings, but the general principles of res judicata are also applicable at subsequent stage of the same proceedings, and therefore the same court be precluded to go into that question which has already been decided or deemed to have been decided by in the earlier stage. In other words, it will be barred by the principle of res judicata, or at least by the principle of constructive res judicata, where the logic here is that the executing court proceeds, execution proceedings works in different stages. And if the judgment debtors have failed to take an objection and have allowed the preliminary stage to come to an end, then res judicata would fall. Lordship, in our case, what has happened? Section 47 was moved earlier also before this Honorable Court. But this issue was never taken. Because, Your Lordship, this issue was hiding under the weight of the collusion between the three parties. This issue was never taken that the decree is void ab initio. And Your Lordship, whether a decree is void ab initio is an issue which comes under the definition of all questions. Lordship, may I place another judgment? This is 2022. Lordship, this is a judgment of 2022 Supreme Court cases. This is a judgment, Your Lordship, of Bombay High Court. 3 judges. 2 judges, Your Lordship. Before 2 judges of the Bombay High Court.
Yes.
I will not trouble Your Lordship. Lordship will kindly come to paragraph 48 of this judgment, 48 onwards. Paragraph 48. The basic question is whether this court is of the view that the consent terms and the order taking them on record is obtained by fraud, collusion, or misrepresentation. It is right that a judgment, order, or decree obtained by playing fraud on the court is a nullity and non-est in the eyes of law. Such an order, judgment, or decree can be challenged in any court. Your Lordship will see the emphasis has been provided. In any court at any time and even in collateral proceedings. In this regard, reliance was placed on the cases of Lordship SP Chingalwalia Naidu. Fraud avoids all judicial acts, electoral or temporal, observed the Chief Justice Edward Coke of England about 3 centuries ago. It is a settled proposition of law that a judgment or decree obtained by playing fraud on the court is a nullity and honest in the and non-est in the eyes of law. Such a judgment decree by the first court or by the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. The High Court, in our view, fell into patent error. The short question before the High Court was whether the facts and circumstances of this case obtained the preliminary decree by playing fraud on the court. The High Court, however, went haywire and made observations which were wholly perverse. We do not agree with the High Court that there is no legal duty cast upon the plaintiff to come to court with a true case and prove it by true evidence. The principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of the dishonest litigants. The courts of law are meant for the imparting justice between the parties. One who comes to court must come with clean hands. We are constrained to say that more often than not, process of the court is being abused. Property grabbers, tax evaders, bank loan dodgers, and other unscrupulous persons from all walks of life find the court process a convenient lever to retain the illegal gains indefinitely. We have no hesitation to say that a person whose case is based on falsehood has no right to approach the court. He can summarily be thrown out at any stage of the litigation. Lordship, in Apaya Shastri versus Government of West India, Government of Andhra Pradesh, it was held Now it is a settled principle of law that if any judgment or order is obtained by fraud, it cannot be said to be a judgment or order of law. Fraud avoids all judicial acts, ecclesiastical or temporal. It is thus settled proposition of law that a judgment, decree, or order obtained by playing fraud on the court, tribunal, or authority is a nullity and a non-est in the eyes of law. Such a judgment, decree, or order by the first court or the final court has to be treated as a nullity at every court, superior or inferior. It can be challenged in any court at any time, in appeal, revision, writ, or even in collateral proceedings. In the Duchess of Kingstone, explaining the nature of fraud, the great Chief Justice stated that though a judgment would be res judicata and not impeachable from within, it might be impeachable from without. In other words, though it is not permissible to show that the court was mistaken, it might be shown that it was misled, which was my submission before your lordship. It was misled. There is an essential distinction between mistake and trickery. The clear implication of the distinction is that an action to set aside a judgment cannot be brought on the ground that it has been decided wrongly, namely that on the merits, the decision was one which should have been rendered, but it can be set aside if the court was imposed upon or tricked into giving that judgment. It has been said fraud and justice never dwell together, or fraud and deceit ought to benefit none. This principle has also been reiterated by the Supreme Court in the case of Srimati Madan Kansagra versus Peri Kansagra. With regard to the scope of the extent of this court's jurisdiction in collateral proceedings, the case of Kishan Lal Bharwa and Sharda Saharan observes, this court finds that on the basis of the petitioner's claim that the decree was obtained by fraud is a report submitted before the Chief Judicial Magistrate by the Directorate of Fingerprint Experts, according to which the fingerprints of Ashok Kumar as existing on the lease deed executed by Noida do not match with those upon the power of attorney claimed by Riduman Kumar Saharan and rather matches with the agreement to sell executed in favor of the dependent petitioner. This report has been prepared by the experts of the Directorate of Fingerprints, who are public servants, and the report is in due discharge of the official duties, and by virtue of the section of 114 the Evidence Act, a presumption of correctness of the report would be available in law, subject to the further evidence which may be brought on record by the other side. The question as to whether a plea of fraud could be entertained even in collateral proceedings at the stage of execution after passing of the decree is no longer res integra. It is settled that fraud and justice do not dwell together. It is equally settled that a court of law would do its utmost to ensure that injustice is not meted out to a party. Such a party in a court of law has been recognized under Section 44 of the Evidence Act. Section 44 of the Evidence Act has been set out, Your Lordship. Reliance has been placed upon a decision of the Bombay High Court wherein plea of fraud was set up in execution and was rejected by the courts below. In such circumstances, the Bombay High Court interfered with the matter and made the following observation. It must be observed that even in execution, if it is shown that the order was made upon mistake of fraud, which affects the very validity of the order under execution, rendering it ineffective, it can properly be questioned by anyone. Section 44 of the Evidence Act in terms of applies to such matters and permits a person to lead evidence to show that the order is not binding any such proceedings. Lordship, in Triveni Mishra, para 13 has been relied upon, which refers to, it may be mentioned here that Sri Kailash Roy, appearing for the defendant respondents, has contended that the question as to whether there was any fraud in connection with the compromise could not be gone into in the present litigation in view of the fact that the previous suit has been decreed on the basis of the compromise and the defendants had not brought any suit for setting aside the decree within the prescribed time limit under Article 95 of the Limitation Act. The prescribed period of time limit for institution of a suit for setting aside a decree obtained by fraud or from any other relief on the ground of fraud was 3 years from the date when the fraud became known to the parties, and the same period of limitation has been prescribed under Article 59. Your Lordship, this is very interesting beyond this. Hence, there cannot be any doubt that a suit by the defendants for setting aside the decree on the basis of compromise on the ground of fraud would have been barred by limitation unless filed within the prescribed period of 3 years from the date of knowledge of the fraud. The question as to whether in view of these provisions a decree or order can be challenged on the ground of fraud in collateral proceedings without any suit for setting aside the decree came up for consideration before the division bench. Lordship, I'll just read out the last paragraph. It is important to remember that fraud does not make a judicial act or a transaction void, but only voidable at the instance of the party defrauded. The judicial act may be impeached on the ground of fraud or collusion in an active proceeding for rescission by way of suit. The defrauded party may also apply for review of the judgment to the title, the court which pronounced it, but the judgment may also be impeached in collateral proceedings in which the fraud may be set up as a defense to an action on which the judgment or an answer to a plea of estoppel or res judicator found upon the judgment. It was further held in this case that the provision relating to limitation as provided in Article 95 of the Limitation Act has no bearing in relation to Section 44. As would appear from the terms of Section 44 of the Evidence Act quoted above, this section lays down that any party to a suit or other proceeding may show that a judgment or order or decree referred to in the section, which has been proved by the adverse party, was delivered by a court not competent to deliver it, or was obtained by fraud or collusion. The right as given by this section has not been fettered by any limitation whatsoever. It is manifest that such a right is quite independent of the right to get judgment or decree, etc., set aside by bringing a regular suit for the purpose. I therefore fully agree with the views expressed in the earlier decision of this court referred to above and hold that such a plea can be raised under Section 44 of the Evidence Act, irrespective of the time when the judgment was delivered or the decree. Lordship, Section 95 of the Limitation Act has also been, Your Lordship, set aside, where a question of fraud has been raised in any proceedings, also in execution proceedings. Lordship, the last paragraph which is highlighted, the last few lines which are highlighted, under Section 44 of the Evidence Act, any party to a suit or other proceedings may show that any judgment or order or decree which it or was obtained by fraud or collusion. The provision of Section 44 is not an idle provision. It is proved that a judgment was obtained by collusion. That fact will affect its force. Force, effect, executability, and value. So it will be absolutely incorrect to say that even if a judgment is obtained by fraud or collusion, that will operate as res judicata in a subsequent suit. That will be giving premium to a sham and illegal deals, shutting out persons striving to uphold their rightful cause or claim by exposing illegal or unconscientiable bargains. Lordship, the next highlight. It was held that an innocent party may be allowed to prove in court that a decree obtained against him in a different proceeding in another court of concurrent jurisdiction was obtained by fraud. But this is not our case, Your Lordship. Lordship, the next page, Your Lordship, there highlights fraud or collusion obtaining judgment or incompetency of court may be proved. Any party to a suit or other or decree which is relevant under sections 40, 41 or 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it, or it was obtained by fraud or collusion. It was held that the right as given by Section 44 of the Evidence Act has not been fettered by any limitation whatsoever. And it is manifest that such a right is quite independent of the right to get a judgment or a decree set aside by bringing a regular suit for that purpose. A decree or an order can be challenged on the ground of fraud in a collateral proceeding. Lordship, I'm not going to trouble your Lordship with the collateral proceedings. But Your Lordship, this judgment, Your Lordship, has gone into all aspects. All aspects. And Your Lordship, the conclusion is that at any stage, before any court, any person.
Distinguishing feature is that you are a party to that fraud.
Lordship,
You are a
per se,
party
Lordship,
to that fraud. Okay.
Lordship, I will place before your Lordship a judgment that when I step into the shoes of my predecessor in interest, I also set up an independent right of my own. I do not step into my predecessor's shoes 100% having no individual right of my own or an individual right of defense. I'll place that judgment. Because Your Lordship, my case before Your Lordship, I can understand, Your Lordship, it also troubled me that since I have stepped into the shoes of my father, can I take a plea which is separate? Can I set up my independent plea? And I will show Your Lordship that we can. Because Your Lordship, once, to the extent, Your Lordship, that in a tenancy matter, the section 6 notice was given to the father. The father expired. The son and the daughter and the mother came into. They said, we have not received a section 6 notice. The court held, yes, they can take that independent plea. So, Lordship, I will place that judgment that I, stepping into my father's shoe, have an independent right of my own, apart from the right what I have inherited from him. Lordship, another submission which Lordship troubles me. Have I inherited my father's fraud and collusion also? Lordship, if my father has committed a murder, it comes to notice after a few years that he has committed murder. Should I go to jail or should I be hanged? Lordship, a fraud of this nature, it's a property of a trust, Your Lordship. A trust is a minor before Your Lordship. Your Lordships are the guardians of a trust. The right of a trust has been taken away. Should I be punished for it? Should I be punished for bringing it to the notice of this Honorable Court? That you have been misled, that you have been defrauded by my predecessors in interest. Lordship will kindly consider, I have nothing to gain. Lordship, this is prime property, Rafi Ahmed Kidwai Road. If I'm not wrong, Your Lordship, it would be going by a crore a kattha. So also if a part of that property goes, Your Lordship, I am in a lose-lose situation always. All my brothers would be against me. Lordship, I am standing all alone. Should I be punished for that? I ask myself this question. Because I'm not doing this, Your Lordship, to gain anything. Lordship will kindly come to the next page. Subparagraph 18, Your Lordship, where a judgment has been quoted. It says, it is well settled that once the plea of fraud has been set up by the defendant petitioner before the executing court and credible evidence in support of such plea was also placed, it was incumbent upon the executing court to have examined the issue of fraud on merits, and such plea ought not to have been rejected merely on the ground that the decree in favor of the plaintiff respondent has been passed, and the executing court has had no occasion to examine the plea of fraud. It is also well settled that fraud vitiates all solemn acts. Though a plea of fraud was taken up before the civil court, but such plea was not adjudicated, which is clarified in the judgment of the civil court itself. However, if material has come into existence, which if found proved vitiates the decree itself, it is a duty upon the executing court to consider such plea on merits. It was open for the executing court to have examined the report of the Directorate of Fingerprint Experts. Your Lordship, this is a very interesting case. In this case, Your Lordship, the decree was passed, the decree was executed. And after the execution of the decree, Your Lordship, the property was sold to a third person. And thereafter, Your Lordship, In a police investigation, fingerprint showed that the deed was obtained by fraud. Came back to the court and the court held no. You have to set it aside. The director of fingerprints, in accordance with law, and for such purpose, an opportunity is liable to have been allowed to the plaintiff respondent. The executing court could have educated as to whether the plea of fraud was made out on facts or not. But it was not open for the executing court to brush aside the objection itself and thereby refuse to go into such an issue itself. Lordship, fraud, your lordship, casts a duty upon all courts, irrespective of the fact who is before your lordship. I may be, lordship, my father, my predecessor in interest may be a party, but a defense of fraud is before your lordship. Just on the ground that my father was a party to that fraud, will your lordship brush it aside, put it under the carpet and say, I will not enter it? The court says, no, you cannot. Lordship, next page. I am only reading the highlights for your lordship. Fraud is an intrinsic collateral act which vitiates the most solemn proceedings of the courts of justice. Lord Coke says it avoids all judicial acts and temporal. But in all cases alike, it is competent for every court, whether superior or inferior, to treat as a nullity any judgment which can be clearly shown to have been obtained by a manifest of fraud. Lordship, towards the end, fraud or collusion in obtaining judgment is a sufficient ground for opening or vacating it, even after the term at which it was rendered, provided the fraud was extrinsic and collateral to the matter tried and not a matter actually or potentially in issue in the action. It also stated, fraud practice on the court is always ground for vacating the judgment, as where the court is deceived or misled to material circumstances, or its process is abused, resulting in the rendition of a judgment which would not have been given in the whole conduct of the case had been fair. Lordship, this is one of my, Lordship will kindly remember, on the first date I had made this submission, that when a terms of settlement are placed before the court, your Lordship, sometimes goes into the terms and settlement. What are your terms and settlement? They have filed a suit that we claim on the basis of a probate. The court, prima facie, your Lordship, because 2 members of the 3 brothers were members of this court. The court did not even go into the terms and conditions, terms of settlement. The court took everything on face value. Everything. Probate, the court did not go into the will. The court did not go into the terms of settlement because 2 members of the bar were before the court supporting that consent, that terms of settlement signed by them. And that is my case. This is not a fraud, your Lordship, interse the parties. This is a fraud specifically on the court. Lordship will kindly consider that. Your Lordship, sitting in the jurisdiction of an executing court, cannot brush it aside. Especially, your Lordship, when my submission is, it is a fraud upon the court.
Anything else? You have completed, I think.
I will, Lordship, this entire judgment, Lordship will, I could place the entire judgment as I'm placing all the highlights. But because, your Lordship, all the highlights are only in support of what I'm submitting before your Lordship.
I have a special bench
I know.
at 12 noon. Rest it.
Lordship, there are other aspects, your Lordship, regarding what is a will, whether it is a trust at all, whether a trust was created at all.
So tomorrow.
Tomorrow.
My lord, can it be day after tomorrow?
Yes, day after tomorrow. The learned counsel for the judgment petitioner under section
Day after
judgment date number 1 or petitioner.
I'm defendant number 1A.
Defendant number 1 has commenced his argument but does not conclude. in respect of petition under section 47 Civil Procedure Code, Code of Civil Procedure. Stop. List the matter. Proceeding 21st. 21st. 21st December. এই অ্যাপিলেট সাইডটা দেখো। অন্যটা নাও। আছো তো এখানে পাশেই থাকো, এক্ষুনি হয়তো হয়ে যাবে। বাবা হ্যাঁ লিস্টে দিয়ে দিন। হ্যাঁ দুটো আছে না? আচ্ছা ঠিক আছে রাখুন।
এক্সিকিউশন এ নিয়ে কিছু বলার দরকার
We have appellate side matters.
মার্চ
We have
18 তে রাখতে।
At 12, we have two appellate side matters,
My lord,
assigned matters.
next two matters, my lord, 11 and 12. My lord, the parties are on the verge of settling and finalizing the documentation. My lord, will keep them on any day in March. We shall come.
18th March, my lord, if kindly.
18th March.
18th March, my lord.
এই ওইটা এই
না রিজনেবলি বলছি 18th March তে রাখো।
ওরা অনেক দেরি করে। আমাদের ইনস্ট্রাকশনস ক্লায়েন্টের থেকে এসেছে স্যার।
Any time in March, my lord.
First week of March.
First or second week of March.
Second week on any date convenient for March.
Any day
18th
convenient.
March I'm praying for, my lord.
Yes.
I'm praying for second week March.
No.
Reasonably.
10th March করে দাও।
10th March.
10th March করে দাও।
11 আর 12.
11 আর 12 করে দাও।
10th March Sunday.
একটা
11th
ডেট
March.
সেকেন্ড হাফে একটা ফিক্স
11th March.
11th March.
10th March is a Sunday.
স্যার
11th
পিএম করে নিন স্যার, ফিক্স করে নেবেন। ফিক্স করে নেবেন।
কি হবে লিখতে হবে?
11th March.
না both the parties লিখে দাও। Both the parties have sought for an accommodation as talk of compromise is going on. Stop. Please the matter on 11th March. Yes.
Sir, daily 81.
Appellate side matter.
Daily listed.
Appellate side matter.
Yes, my lord, under compelling circumstances, my lord, we are mentioning a matter in the appellate side, my lord, that is WPA number 4011 of 2024.
WPA number?
Yes, 4011 of 2024, in which my lord was pleased to pass an order on 13th February 2024.
Yes.
Now, my lord, this is the matter, my lord, in which a particular area, my lord, or in the state of West Bengal, that is Sandeshkhali, my lord, is involved. Now, my lord, the situation there is, it's a, my lord may find it from the Google Maps also, this is a landlocked area.
You are appearing on behalf of whom?
My lord, I'm appearing for, my lord, we are appearing for the persons, my lord, who are staying, the victims. Well, we have been instructed because they are not being able to access, and the problem there is
tomorrow is the
tomorrow is matter. What we are praying for is
on tomorrow. At
Tomorrow.
12 noon. Yes, I cannot tell you because I have to ask the
No,
amicus.
Amicus.
Amicus is there.
We have
and
given,
there
we have attempted to serve. I will serve both the public prosecutor.
No, I am not giving any direction. You
No,
please
we have
come tomorrow, then I will decide.
only pray. But may I just
No,
pray for something and
I have taken this initiative my own. I know this is my baby. I know how to nurture, how to look after. Okay, come back on tomorrow. Next.
may I only pray for one indulgence? Say if
Yes.
my
At
lord,
12 noon.
No, 12 noon.
Speak time.
No. That is that once it has fallen from my lord, it is our duty to. My lord, the only indulgence I'm praying is this because of the safety and security of the victims and witnesses, especially the women. My lord, tomorrow allow us to represent the case because we are not getting someone to come from there to.
I have forgotten everything. I cannot remember what happened. Okay, come back on tomorrow. You have seen from me from as a chief judicial magistrate Alipur. Okay. Next term.
Deep table.
Okay.
Item number 1.
কি ভাবছি আমাকে?
But I beg to appear on behalf of the petitioner, my lord.
Kanailal. What is that? The new case, no?
In the revisional application, my lord,
You are
for the petitioner, my lord.
revisionist or something like
My
that.
lord.
And who is for the other side?
We have served, my lord, but
So give some time.
Substitution.
Substitution has already been allowed. My lord, thereafter, my lord, the son of the sole opposite party has already died. We have filed the application for substitution also.
Okay. So that has not been taken care of, I think.
No, my lord.
This is an application for substitution on the sole opposite party who died.
May I humbly submit one thing?
Opposite party died.
Sole opposite party.
Yes. Who
We have
died
filed the application that has been allowed.
leaving me 4 sons and 2 daughters, such and such. The application for substitution is within time and legal heirs of the opposite party
My lord.
are sui generis and right to survive. Right to survive.
One of the son has died in the meantime.
Oh, what is his name?
Samuel. Samuel, my lord. And my lord, that application has already been filed.
Samuel is not there. Sama Prasad Bhattacharya.
Sama Prasad. Sama Prasad, my lord.
So you have filed an application.
Application, my lord.
Oh,
That is can 3, my lord.
can 3. When he died?
No, we are not aware, my lord, regarding the actual date, my lord, my lord. We have come to learn that he has expired, so we have filed the application, my lord.
He died on 17 July 2021, according to our information. 17 July.
My lord, perhaps on 17 July 2021, we got some information that on 17 July 2021.
And when you have filed this application?
In application filed on, my lord, 11 July 2023.
17 July died, 11 July filed. I do not understand.
11 July 2023, my lord. That was in 2021. We filed in 2023.
Then abated.
In between there, my lord, the pandemic was there, my lord.
So what about the other?
We have served, my lord.
What is the affidavit of service?
My lord. One of them
they
has
do not know that the matter will appear today. So give them notice, okay, and come back.
My lord. But this is the affidavit of service. One of them has received, others have not.
Okay.
They file it, my lord.
Okay. Affidavit of service is taken on record. Stop. However, the learned counsel is further directed to serve notice afresh upon the concerned parties. This the matter after 7 days.
No, my lord. It's Nodia. 10 days, my lord, at least.
10 days. This the matter after 10 days. Ki একটা date হবে beginning? কোনদিন হবে? আজকে তো আসছে আজকে কত তারিখ? 29th February. 29th.
May I seek one indulgence, my lord? My lord, may I be directed to serve the notice upon the learned advocate who is representing them in the court below, my lord? That will perhaps suffice, my lord.
The learned counsel is also granted liberty. You have to
both ways.
Both ways.
My lord.
And the learned counsel is also directed to serve the notice upon the learned advocates of the parties in the trial court.
My lord.
Learned counsel of the opposite parties in the trial court. Okay.
February? 29th February, my lord.
29th.
Special day.
Special day.
Great, my lord. Sir, I am filing the service, my lord. Item number 2.
My lord, this is my application.
দেখি এটা দেখি তো অর্ডারটা দেখি তো আগের দিনে
Chair for the state in this matter.
I appear for the respondent bank.
I'm drawing your lordship's attention at page 54, my lord. The contention of the revisional applicant is this.
Learned counsel for the bank has sought for an accommodation for apprising this court in respect of rules regarding banking ombudsman and other banking regulations regarding recovery of dues from the concerned customer.
Under Banking Ombudsman Scheme 2006, any complaint, the primary complaint of the petitioner herein is charging of higher rate of interest in the gold loan, your lordship. Now, the ombudsman, the learned banking ombudsman is the authority wherein such sort of complaint, if at all the petitioner has can be filed, and he has the authority to adjudicate the same. So this under scheme, Your Lordship, I beg your pardon, the first page of the it's incomplete. I can file if, within an hour the complete scheme, Your Lordship, of 2006. I have got, but the first page is missing from my brief. So this is
In course of the day.
yes, Your Lordship, I can file. I'll also hand over a copy.
Copies to go to.
Yes.
Okay, yes.
Yes, Milord, the contention of the revisional applicant is this, Milord. First of all, there is a fraud committed by the bank, Milord, as because the petitioner's
You have
wife.
taken loan. You have taken loan.
Yes, petitioner's wife has applied for a term loan and it was converted to a gold loan. And Milord, that has specifically admitted by the bank, Milord, by its reply at page 54. Initially, Milord, got it? Page 54.
So your wife has had the bank account.
Milord,
Your wife
for
not have
obtaining,
any bank
subject
account.
to correction, Milord, for obtaining term loan from a scheduled bank under the Reserve Bank of India. Opening of account is not mandatorily required even after the
How the loan amount
yes,
will be
even
given? How if you do not have the account, how you will get the loan?
gold loan is also being served from the other bank account, Milord. It is not that they have the account with the HDFC bank.
Okay.
When this gold loan was opened.
Okay.
So, Milord, what is the reason they have assigned? Note initially your client approached
54 or
54.
Yes.
Paragraph number 1, 2, 3, 4, 5, 6, 7.
7.
Note initially your client has approached for a term loan in the name of his wife who does not have any bank account, and your client has not ready to open savings bank account to HDFC. Might be because higher deposits.
You have received the loan amount. What is the loan amount?
That is 5,17,000. That is written here, Milord. And the wife of the petitioner cleared the loan, and that is also arranged by the bank. And now the petitioner is the borrower.
So you have paid the EMI. So far as the gold loan is concerned.
I have gold loan offered the payment of interest, Milord, and payment of a lump sum.
No. There is no scheme of EMIs.
There is no scheme of EMI. Let them say that there is a scheme of EMI.
Monthly.
No, there is no equated EMI system. They have not given that. Only what they have given, Milord. I am showing your lordship, Milord.
Your Lordship, perhaps the...
Let me finish.
No, I just clarified how the gold loan operates, Your
Milord,
Lordship.
let me finish.
Yes, certainly. I want to clarify. In gold loan, Your Lordship, it is for a certain period. The loan is granted. Every month, the borrower has to serve the interest, and upon the expiry of the period, either it has to be paid off the entire principal amount, and has to be closed or has to be renewed.
Yes.
So yes, every month the interest has to be served.
So whether he has paid or she has paid the interest part every month.
Yes.
Initially.
Yes.
That is the matters of record. The interests were being served. However, there is a substantial, since the account neither has been closed nor has been renewed, there is a substantial amount due and payable under the subject account at present, Your Lordship.
Okay. Milord, page 42, Milord. This is the way they're...
Otherwise, Your Lordship, it's just totally a contractual dispute, Your Lordship. On a criminal angle is being brought, Your Lordship, just to pressurize the bank.
Next, Milord, these are the contract paper, Milord.
Judgment. You have filed.
Priyanka Srivastava on different footing, Milord. Where the Priyanka Srivastava is different footing, Milord. Where the SARFAESI Act has been already applied by the financial FIs. Here there is no question of invoking the SARFAESI Act because Milord, it will be appearing, Milord, from the document.
Why this is a criminal case? Why?
Yes.
Why?
First of all, Milord, there is a misrepresentation from the initial, Milord. I have come before the bank with a prayer for term loan.
IPC has been defined this offense as misrepresentation. The offense of misrepresentation.
Yes, Milord.
Is there.
If I am not even there, Milord,
misrepresentation we can find in the contract.
I am protected under the, Milord, the West Bengal Protection of Interest of Depositors in Financial Establishment Act 2013.
Yes.
Devin Joseph Ekbar.
Why this is criminal? Yes.
Now, my lord, I am coming to the internal section, internal page 4. Financial establishment is defined under section 2E. Means any person or a group of individual or a corporate body, corporate body or a partnership firm, including director, promoter, manager, or member of the establishment, accepting deposit under any scheme or arrangement in any other manner, but does not include banking company as defined section clause C of the section 5 of the this one. But again, my lord, I shall draw your lordship's attention at section 3(1), wherein the financial establishment fails to render, my lord, B 3(1)(b) is fails to render service, product, or asset promised against the deposit, fails to render any specified service agreed. My lord, this includes the banking authorities.
Okay, we have no problem. But why this is all in civil nature? The dispute is of civil nature.
My lord, misrepresentation is very well coming within the, and my lord, misappropriation and misrepresentation is coming under the, my lord, 406.
So criminal breach of trust may be there.
Yes.
You are not raising this issue.
Yes, I have
why
already
criminal
raised.
breach of trust?
I have already said so, my lord.
Why?
In my 156 application.
156(3).
Yes.
Yes. Criminal breach of trust.
And my lord, that contention has already raised by the Reed Court, my lord. And it has been upheld, my lord. That is the order, my lord, passed by my lord Justice J. Sengupta. That, my lord, at page 32. Learned counsel appearing on behalf of the petitioner submits as follows. The petitioner has taken a gold loan from a bank. My lord, got it? Page 32. Being an extra P2 of my petition.
Yes, yes.
That is, my lord, 1, 2, 3, 4. Fourth paragraph.
Yes.
Learned counsel appearing on behalf of the petitioner submits as follows. The petitioner has taken a gold loan from a bank. However, the bank authorities thereafter contended that he had applied for a term loan. And that is already admitted by the bank. Higher interest rate was charged. And in the process, substantial sum embezzled. So this is required to be investigated.
No, this is your submission.
Yes. Then,
it has been recorded.
Then, my lord, come to the, my lord, internal page 2 of the order sheet, my lord.
Yes.
Then, my lord, I am referring 1, 2, 3, 4. My lord, fourth paragraph, it is not clear. It is not clear as to why police have chosen to conduct a preliminary inquiry. Whether in the particular case, preliminary inquiry is at all essential when there is a particular statute is there. It should actually have been made clear in the report. However, according to them, no offense is made out. Police is from the initial, they are giving the report that no offense has been made out. But normal records available, this is the normal, and 156 clause 3 has been suggested. So, my lord, my case is that there is an embezzlement of fund which has already been admitted by the bank, that my wife appeared and said that there is a applied for a term loan. And it is not that I'm a defaulter or anything else. I'm not qualified to be obtained term loan. There is only one issue, that the savings bank account. And, my lord, the gold loan was issued. Actually, gold loan is giving on the higher rate of interest. And that has been deducted from my bank account, my lord. And thereafter, my lord, I have paid the entire dues. And that sum has been arranged by the bank officials. And thereafter, my lord, the entire loan was transferred to my petitioner.
Substantial sum was embezzled.
Yes.
This is your content.
Yes.
So how that
yes.
portion of the interest sum was taken?
Kindly come to the, my lord, my complaint which I have lodged before the police. That is under section 154.
Page number?
Page number 25.
Yes.
I, Topun Rai, let such and such. It is required, my lord. I am coming to the second paragraph. That is the content of the applicant. It is required to be mentioned in this context that pre-existing illegal practice were initiated beyond the banking norms. And such practice is in contravention of the guidelines of the Reserve Bank for India or for its scheduled bank. It is further necessary to mention that the wife of my client, namely Basanti Raipal, applied gold loan for 4,87,000 on 6th April 2021 and offered gold ornaments mentioned mentioned in the schedule of the said loan document as securities of the said term loan. It was initially, she was under presumption it is a term loan. But the manager sales of the HDFC Bank processed the said loan application as overdraft loan of rupees 4,90,000 and sanctioned on 6th April being account number such and such, continued 26th June 2022 for 15 months and the HDFC Bank received 92,937 ওটা পরে আসছে from the wife of my client, which is 19% of the principal amount. This is my initial contention.
So this is a rate of interest with a higher rate of interest are all matters
whether
of civil agreement or contractual matters.
This is not totally, this is totally fraud, my lord, made by the bank, my lord. Let there be an investigation at least, my lord. And, my lord, this investigation to be made, my lord, under the supervision of
You have mentioned in your third paragraph, the bank have charged more the agreed interest, that is more than the agreed interest.
Yes.
That is your contention, basic contention.
My lord, this is if that be so, my lord. If that be so, that bank has charged more than the agreed rate of interest, that is also fraud, my lord.
No, maybe there may be a fraud, but this fraud is to be adjudicated in the civil courts. Okay, not. Please tell me.
My lord, thereafter, my lord.
Oh, you have not finished. You have not finished. Okay. Next.
It is pertinent to mention in this context, upon received the said notice dated 13 February 2023, my client already lodged a complaint which is registered as complaint case number, that is with the bank. Then, my lord, bank has internal organization, internal system to make this complaint and consider this complaint. They have not made. On the contrary, they have accepted the contention that my wife initially applied for a term loan.
But it has been converted into gold loan without
my contention,
without
my consent.
Oh, that is.
And if this consent has been obtained upon fraud or misrepresentation, that does not tantamount to criminal intimidation.
You sign the documents. You sign the documents also.
My lord, first of all, bank has, it is already bank stated that note that your client Simoti such and such initially come before the term loan. Whether bank has taken any undertaking from the borrower that your term loan, you are not eligible for the term loan, therefore this gold loan has been made. No, this is the contention of the bank. So first of all, they have given, because the gold loan is charging higher rate of interest rather than term loan, and this gold loan is charging in such a fashion, it is an unending system. So this way, my lord,
this is the only contention that your client,
I have already till date.
Your client's wife has approached the bank for term loan. Your client's wife had approached the bank for a term loan, but they had given you a gold loan without obtaining your consent.
Yes, only signing document, my lord. First of all, I am to make.
But you have received the loan amount. You have received the loan amount.
And I am paying.
Paying the interest.
I am paying, and payment.
It is better place that banking ombudsman should take care of.
My lord, at least, my lord, let there be an FIR, my lord. Let there be a FIR.
Under which section?
Under 420, 406, my lord. And, my lord, there is a specific provision under the under section 3 of the West Bengal Protection of Interest of
What
Depositors.
is the order passed by the learned judicial magistrate? Where is the order?
Judicial magistrate.
Today it
They-
speaks to a report.
Yes, that is on the basis of the Milord, this Priyanka Srivastava and another versus State of Ethiopia and another. Milord, the Priyanka Srivastava judgment has given before your lordship. It is a case when
You
the
submitted, no? You submitted.
yes,
From state, from this, yes.
it is a case where the borrower trying to restrain the particular bank which is going to recover the amount under the SARFAESI Act after issuance of the 13.2 and 13.4 notice. Here it is not the case.
It's not applicable.
Not applicable.
Okay. So you have concluded, I think.
Milord, my case is this, Milord. I am coming directly to the Lolita Kumari.
Hey,
Lolita Kumari is also applied here, Milord. Here,
এই নোট নিয়েছিলাম কিছু নিইনি না না নোট নিয়েছি কিনা দেখুন
এই তোমার ওইটা দাও তো আমাকে।
হ্যাঁ
এখান থেকে পড়লে
ললিতা কুমারী
Before Lolita Kumari, Milord, I am coming to the Srivastava first, Milord. একটু দিন না। Milord, kindly come to the page 13. Sorry, para 13
of what?
of the Lolita, of the Priyanka Srivastava.
13, yes.
Milord, at this juncture, we are impelled to look at the past again. The respondent had preferred has been stated before an appeal before the DRAT. So, then, Milord, the observations were made. And, Milord, under the SARFAESI Act, all other legal proceedings are not maintainable.
Yes.
So, Milord, from the on the basis of the preliminary report has been directed, Milord, and on the basis of the preliminary inquiry, the the 156 clause 3 application was disposed of. Milord, then again, Milord, page paragraph 14. The labyrinth maladroity created by the respondent number 3 does not end here. It appears that he had indefatigable spirit to indulge himself in the abuse of the process of the court. Respondent number 3 had filed an application under section 156 clause 3 of CRPC. Here it is not. Because 156 clause 3 is barred when there is a appeal pending before the DRAT. So, Milord, the Priyanka Srivastava case is not applied when I have applied under section 156 clause 3 before the learned judicial magistrate. Then, Milord, paragraph 20, this is the same thing which has been reiterated by the earlier judgment of the apex court, Milord. Then, Milord, paragraph 21, dealing with the nature and power exercised by the magistrate under section 156 clause 3, a 3 judges bench in Deverapalli Lakshmi Narayana Reddy versus V. Narayana Reddy had to express that it may be noted that an order under subsection 156 clause 3 is in nature of peremptory reminder to or intimation to the police to exercise its plenary power of investigation under section 156(1). Para 21 of this.
Of what?
Of Priyanka Srivastava.
21. You are not relying or relying?
Milord, I am relying, saying that the fact of the Priyanka Srivastava is not applied to my case.
Then,
so, Milord, the learned judicial magistrate is a bit confused when he has issued the direction for preliminary inquiry. Second, Milord, I am well protected by the Lolita Kumari, Milord. ললিতা কুমারীর আমার কাছে এক্সট্রা নেই। This is, my lord, reported on 2014 volume 2 Supreme Court cases, page 1.
Yes.
It's a very elaborate judgment, my lord. I am coming to the conclusion, my lord. My lord, conclusion is starts from paragraph 120. In view of the aforesaid discussion, we hold that registration of FIR is mandatory under section 154 of the code if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such situation. So, my lord, the preliminary inquiry which has been made by the Priyanka Srivastav case and in my case is totally different. When I say that the consent has been made upon obtaining fraud, so my complaint is required to be registered and FIR is required to be registered and investigation is required to be initiated.
If your petition does not disclose the offense,
Yes, my lord,
the nature of offense, then
my lord, it is
judicial magistrate is bound to
my
direct.
lord, it is disclosing.
For the sake of your client, magistrate had asked the authority to submit a preliminary report because your petition does not disclose any offense, cognizable offense. This is my content, sir. I'm not saying anything about your case. Your petition is to be disclosed.
I have already, my lord, shown my complaint I have made under section 154, my lord, and the bank replied to the advocate's letter, my lord.
If it is a civil nature of dispute, then magistrate cannot allow 156.3.
There may be a, yes, my lord, it's a contract after all, my lord. The cause of action may be arising out of the contract. But if the consent is obtained upon fraud,
at best, CJM can exercise the power of section 200 CRPC. Complaint case
can be made.
Yes.
My lord, last.
You did not finish as yet.
My lord. And my lord, then my lord, I am relying on 2008 volume 2 SCC, page 409.
Once again, please.
2008 volume 2 SCC, page 409.
409. Yes.
Judgment to the My lord, I'm starting from the paragraph 14. Section 156 clause 3 states that any magistrate empowered under section 190 may order such an investigation as above mentioned. The word above mentioned obviously refer to the section 156 clause 1, which contemplate investigation by the officer in charge of the police station. Section 156 clause 3 provides for the check by the magistrate on the police performing its duties under chapter 12 CRPC. In cases where the magistrate finds that police has not done its duty for investigating the case at all or has not done it satisfactorily, he can issue direction to the police to do the investigation properly and monitor the same. The power in the magistrate to order further investigation under section 156 clause 3 is an independent power, does not affect the power of investigating officer to further investigation the case even after submission of his report under section 173 subsection 8. Hence, the magistrate can order reopening.
Why this is not your case?
This is not my case.
Then why you are reading?
In our opinion, then, my lord, page 7, paragraph 17. In our opinion, section 156 clause 3 is wide enough to include all such power in a magistrate which are necessary for ensure a proper investigation and includes the power to order the registration of FIR and of ordering a proper investigation if magistrate is satisfied that proper investigation has not been done or it is not being done by the police Section 156 clause 3, though briefly worded in our opinion, is very wide, and it will include all such incidental power as are necessary for ensuring a proper investigation. This much.
Okay. Yes, State Bank.
Yes, Your Lordship, my learned senior friend has made all best efforts to give this case a angle of criminal offense where there does not exist anyone, Your Lordship. There are several submissions which are being made today.
Just your 156.3 petition in
That is
which
annexed
page?
P1.
51.
P1. I'm referring that.
It's a letter dated.
51.
No, not 51.
And
It
page
is at
25.
Page 17, my lord. Starts from page 17.
17.
MP case number 1438 of 2023.
Okay. Just a minute. For taking notes. Petition under section 156.3 CRPC. Page 17. Yes, next.
Neither the letter of complaint, which is annexed at page number 25 of this revisional petition, nor this petition under 156.3 disclose any commission of any cognizable offense, Your Lordship. The entire allegation is charging high rate of interest, Your Lordship. If Your Lordship go through this letter of complaint as well as this 156.3 petition, the primary contention is charging of higher rate of interest. Several other contentions submission has been made today, which does not make part either of the letter of complaint or 156.3, Your Lordship. The misrepresentation and this conversion of term loan into a gold loan, Your Lordship. This does not make any part of this petition of complaint, Your Lordship. And otherwise, this is incorrect submission, Your Lordship. Kindly appreciate, first of all, also the application for the gold loan, which is annexed by the petitioner himself, Your Lordship, at page number 40 and 41.
40
and 41, the revisional petition application, Your Lordship. This application itself clearly in bold letter has Your Lordship got page 40, Your Lordship.
40.
Yes.
40.
40.
Yes.
This is the application for gold loan, Your Lordship. This in bold letters clarifies that this is an application for gold loan application form. And page 41 contains the signature of the petitioner. Even page 40 contains the signature of the petitioner. So no dispute, no allegation with regard to forgery of signature.
Tapan Rai, Tapos Rai or Tapan Rai?
Tapan Rai, Your Lordship.
Tapan Rai. The petitioner or petitioner's wife?
No,
it is
this
the petitioner.
my lord. The second time loan, my lord, after the entire sum was transferred to the account of the petitioner, my lord. And that transfer is also made on the fraudulent manner, my lord. That is also contention raised in the 156 clause 3.
They have signed the proposal form, Your Lordship, the application for gold loan.
What is the profession of Tapan Rai?
He is a practicing advocate, my lord, of this court.
So
no allegation of forgery of signature is made, Your Lordship. If the petitioner is a practicing advocate, Your Lordship, I don't want to make any further submission. Gold loan application form.
You are not aware.
Your Lordship, I was aware, but I did not want to say so. So there is no question of misrepresentation. No case of forgery of signature is made out, Your Lordship.
No case of.
Cannot be any misrepresentation, Lordship. The signature is admitted one. He has not alleged that my signature were forged. And a practicing advocate can definitely differentiate between an application form of gold loan and term loan, Your Lordship. Kindly come to page 54, which was shown by my learned friend, to say that the bank has admitted so many things, term loan was given. However, my learned friend did not read the entire email, Your Lordship. Kindly, I'll read only the second last paragraph, which clarifies everything. There was no misrepresentation. There were two separate loan accounts, Your Lordship.
There are two separate accounts.
One was already closed,
No,
and
my lord.
subsequently.
First one was in the name of the wife.
May I just clarify?
Get the
May I just
opportunity. Yes,
clarify?
get the
This
opportunity.
email itself clarifies
There are
what submission were made.
there are two accounts.
Yes, they were.
There
These
were
are the
one
two.
account in the name of wife, and subsequently it was transferred in the name of the petitioner.
These are two separate things. So
Page number 54.
54. This email has been placed. However, the second last paragraph of the email was not placed.
Second page.
Second last paragraph of the page 54, Your Lordship.
Yes.
Yes. May I read this? Please note, initially, this email was issued in reply to their allegations, Your Lordship, by the bank. Please note, initially your client has approached for a term loan in the name of his wife who does not have any bank account, and your client was not ready to open a SB account with SDFC. As per our internal norms, term loan can be disbursed with 6 months upfront interest to the external customers exclusively. However, your client was not willing to avail the upfront interest option. Hence, he opted for zero balance OD account instead of 10K regular SB account and availed OD facility at the rate 10% rate of interest, which was processed with his consent, and OD agreement was duly signed by his wife in presence of the customer at our gold loan desk under CCTV surveillance. Your client has cleared interest on overdraft account number such and such. Kindly note the account number. It ends with 91393. As per the norms and payments pattern, same has been admitted by your client as he has signed the requisite documents at the time of closure. So this account, this OD account has already been closed. Term loan account was never.
His signature by whom? Was it Topon Rai or his
That
wife?
was of his wife.
His wife.
That has already been closed. Now, the above interest does not pertain to your client's above mentioned gold loan account number such and such, which ends with 0023, as the same has been taken under upfront mode rupees such as that. This is the interest amount has been deducted as upfront interest. No more interest has been paid by your client. Your client has made a payment of rupees 5,500 on such and such and such and such. So initially, OD account, he did not, for opening a term loan account, he had to maintain a savings bank account, which they refused to do. So that was not done. An OD account was opened, this was closed, and this gold loan is a separate account, Your Lordship, in which a substantial amount is still due and payable. So, Your Lordship, the basic contention, there is no allegation of forgery of signature. The allegation of misrepresentation also goes because the gold loan application form clearly mentioned that this was for the gold loan application, Lordship. And the rate of the dispute with regard to the gold loan was sanctioned at a fixed rate of interest. They have alleged a higher rate of interest which is being charged by the bank. But this is the mere allegation where it has been shown, Your Lordship. And in any event, it does not make any criminal offense, Your Lordship. Even there is this can be at the best called as irregularity on the part of the bank or non-observance of directives issued by RBI with regard to charge of interest. So that also does not amount to. There is an banking ombudsman which is sitting there to resolve all these issues, though I am not admitting, because it was charged as the fixed rate, it was issued at a fixed rate of interest, and the same interest is being charged at the gold loan account. It does not vary. So no question of charging of any high rate of interest arises, Your Lordship. The third submission, which was placed by my learned senior friend, that the Reed Court has also made observation, Your Lordship. No such observation has been made with regard to commission of any offense. This was the Honorable Court only quoted the allegations, which were raised by the petitioner. So no such observation is being made. And with regard to the inquiry which he is again asking for, Your Lordship, this has already been done. And no offense, commission of no offense has been found. And on the basis of that report only, the learned magistrate, Your Lordship, has dropped this proceeding, Your Lordship. So there is no illegality or there is nothing. The entire thing has been done as per the what the act provides, your lordship. The code of criminal procedure provides, your lordship. There is no commission of no offense. It's a totally a contractual dispute, which why this has been done just to pressurize the bank, your lordship. Because at present, around the outstanding under the said gold loan account is, your lordship, 4,75,317 rupees, your lordship.
Due.
Yes, your lordship. Because
Due amount,
loan amount was 5,17,000, interest was 9.5%, your lordship, which was to be served monthly, your lordship, and this entire amount has to be paid at the when the loan is due for renewal. Either it has to be renewed or it has to be closed by payment of the principal amount, your lordship. So since this has not been done, there is a substantial amount due, and only with intention, the moment this is statement of
4,17,000.
4,17,000. Yes, your lordship. 375,017. So only with intention to create pressure, your lordship, upon the bank to close the loan account or to come to one-time settlement, to agree to at a lesser amount, this entire angle of criminality is being tried to being given, your lordship. There is no offense has been committed by the bank. If this is settled, that in each and every case, then the bank officers and the bank as every juncture has to face criminal charges, your lordship, because this is the amount public fund is being given to public. If each and every loan account attracts a criminal offense against the bank officers or bank, then it would not be possible for the banks to do their banking business. Either it has to close or it has to face charges in at each and every step, your lordship. So my submission, the learned court below rightly dismissed, dropped the proceeding, your lordship, and this revision application should also be dismissed, your lordship.
Yes.
May I be given allowed to?
Yes. Only law points, nothing more than that.
My lord,
only law points.
Law point is that, my lord,
already given you.
Yes. My lord, law point is that
Lolita
before investigating the entire thing, when there is a clear admission, my lord, then, my lord, why the FIR should not be registered, my lord?
Okay, that's all. Yes.
And it is already admitted, my lord, by my learned friend, that there is a irregularity, my lord.
No, I am not admitted. I have said that if at all it can be said. I have not admitted that there was any higher rate of interest charged.
Eligundo, the learned counsel for the parties have placed their arguments in full stop. Please the matter. কবে যায় 26 হ্যাঁ না 26 না 5th March করুন 5th March for orders. Do you have anything to say? You have submitted this Priyanka Srivastava. Learned counsels and have placed their arguments in respect of the instant proceeding, in full. Have placed their submission in respect of the instant proceeding in full. Full, FU double L. Stop. Okay. This is the matter for orders. 5th March for orders.
Deeply obliged.
এটা রেখে দিতে হবে, এটা নোটের সঙ্গে রাখতে হবে, কিন্তু পাঠিয়ে দিতে হবে। এই দেখুন এইখানে লেখা ছিল একটা, আমি বললাম। যাই হোক, এটা এর সঙ্গে পেছনের দিকে পাঠিয়ে দেবেন আমাকে। হ্যাঁ, এইগুলো হ্যাঁ, ঠিক আছে। আবার কালকে 12টার সময় আসতে হবে বোধহয়। আপডেট সাইট আছে কালকে। আপনাদের ঠিক থাকে না, কালকে বোধহয় একটা আছে বোধহয়। যাকে পাঠাবে
4210 4210 না কমার্শিয়াল নন কমার্শিয়াল Original side matter. Item number 13.
My lord, item number 13.
13 though?
Ah.
Yes, yes. 13.
My lord, in item number 13, I appear on behalf of the decree holder. My lord,
Yes.
last occasion also we had submitted that documents asked for had not been submitted, due to which we are not being able to carry out the cross-examination of the judgment debtor. My lord, till date, no document has been submitted. On every date, they come and they take time on behalf of their senior.
Your brother is not here. Pass over.
174210.
Monthly list হয়েছে
এটা আসছে না এখনো না? কিন্তু কাজ করছে না?
Has been.
Oh.
Ah.
Yes, give 2 minutes time. Then আসতে বলো। না, আমি যেটা বলছি শোনো। এটা পাস ওভার করছে না। সে পাস, ঠিক আছে।
Item number 14.
Item number 14, my lord, I am for the judgment debtor.
I'm for the decree holder.
Lord, on the last occasion, examination of the judgment debtor was almost completed. But today, as per what I have understood, that today my learned friend will show that whether execution can be proceeded in respect of properties which are not within the jurisdiction of this honorable court. But before that, my lord, I submit that there are 2 other hurdles which my learned friend has to cross. Only thereafter, this question will be, whether this question is at all relevant, is not, will be before your lordship.
Whether who passed this order? You or
No,
me?
my lord.
What is my order? He
Lordship.
has to comply that order only. Okay,
Lordship.
take your seat.
Lordship,
Head
perhaps
counsel for the decree holder has submitted that this court has the power to attach the properties which have been admitted by the judgment debtor as her properties. Okay. Learned counsel for the judgment debtor has raised objection. Your objection has been noted.
Yes, my lord, that
You
is my
see,
objection.
Learned counsel for the decree holder has sought for accommodation for submitting on this point. On the next, this question has fallen from me, and she has a duty to satisfy me.
That I bow down to your lordship, but before that,
I did not pass, but if you try to argue, I shall pass the relevant order.
My lord.
Later,
Very
Hello?
well, my lord, very well, very well.
okay, I shall hear your objection.
Very
No
well.
problem.
Lordship.
Yes.
On the last occasion, your lordship, what had fallen from your lordship, there had come up one property, which is the decree, the judgment debtor is
Bengaluru.
Lordship. The judgment debtor is the owner of such property, which has been disclosed in the affidavit of assets. They have disclosed with regard to one property, and she is the present owner of the same. Lordship, on the last occasion, lordship, I ought to have placed this before your lordship. Lordship, in my tabular statement, your lordship, I have made a prayer for appointment of a receiver. That is my prayer E. E. Lordship, I'll be first placing the 2 prayers, prayer E and F. Prayer E is a fit and proper person be appointed as receiver over the assets of the judgment debtor, and to sell the said asset by private treaty and or public auction, and to make over the sale proceeds, or so much thereof as may be sufficient to satisfy the decree dated August 30, 2019, passed by His Lordship, Honorable Justice Shivkant Prasad, to the decree holder in pro tanto satisfaction of the decree. And my prayer F was, the receiver be directed to make over the net sale proceeds arising out of the sale of the assets of the judgment debtor, or such thereof as may be sufficient to satisfy the decree dated such and such, passed by the Honorable Court. Your Lordship, what had fallen from your Lordship on the last occasion, whether your Lordship may pass order for execution of the property which is lying outside the jurisdiction of this Honorable Court. Lordship, perhaps that was the only query which had fallen from your Lordship.
Lordship, there is no bar in appointing a receiver who can go and take possession of any of such properties in any part of any other place outside the jurisdiction of this honorable court. That is my first submission. This is my first submission because this suit is a money suit.
I have to transmit the degree or something like that.
Lordship, no, not at this stage.
That's why I want to know what is the law.
Lordship, I'll be relying on one judgment. Lordship, but prior to that, your Lordship, there are two submissions which I may make before this honorable court. My specific prayer was for appointment of a receiver so that this property can be first taken and thereafter the direction shall be passed for disposing of such property, not at this stage. Lordship, that is my first submission. And the primary reason for making such submission is this suit is for money. Lordship, my first subject matter of the suit was a money suit. Lordship, that's my first submission. Lordship, second, on the last occasion, the judgment debtor has accepted that there were two other properties and she has sold it off in the year 2017. And the sale proceeds, as has been admitted by the judgment debtor in question number 28, 29, and 33, 32, 31, 32, 33, that she has received an amount of rupees 1,25 lakhs from such sale of such property. And Lordship, she has not disclosed the account details where she has retained such amount. Your Lordship, this details ought to have been disclosed in the affidavit of assets. And therefore, your Lordship, on the last occasion, your Lordship, therefore, your Lordship, the judgment debtor was not discharged only for this sole reason. Lordship, there remains two properties. One is the movable property and the other, as has come up from her admission, the amount of 1,25 lakh she ought to have disclosed. What she has disclosed in the affidavit of assets is a income tax return of the year 2014 and 15. She has very tactfully disclosed that, and thereafter she declares, I have retired and I do not have an income, and the amount which is secured after sale of such property cannot be termed as my income. That was a submission made on the last occasion. Your Lordship may kindly take note of such statements made by the judgment debtor on the last occasion.
So I think
Lordship, so with regard to
judgment debtor has been cross-examined by the learned counsel in part.
In part.
You have not completed.
Lordship, I could not complete because on the last occasion only one question had arisen that she has to disclose before this honorable court with regard to the accounts from the year 2017. And a stand was taken by my learned advocate for the judgment debtor that pre-decretal property cannot be subject matter. Lordship, subject to correction, that submission cannot stand when the suit was instituted, the decree was passed in 2019, and the loan was taken in 2013. So the cause of action arose from the year 2013, and the sale was made only in between with a presumption that such property may be attached. What that also had fallen from your Lordship on the last date. And Lordship, as on date, if even 1 rupee is
I have to attach the bank account.
Bank accounts, your Lordship.
So what is the particulars?
Lordship, that particular she ought to have provided. Lordship, she has admitted.
If she does not provide, then what is?
Lordship, then I'll press for the other prayer. Lordship, there is another prayer which I have made out in prayer D. The judgment debtor may respondent be arrested and detained in civil prison. Lordship, perhaps to that extent, your Lordship is exercising jurisdiction. Either she has to come up with, Lordship, an affidavit of assets.
Yes, my lord.
Now your turn.
Yes, great.
So,
now, my lord, the question which fallen from your lordship is still remained unanswered, at least from their side, that whether a court which do not have the jurisdiction over the properties which they are trying to sell is at all the court can function, exercise this jurisdiction or not. That they have not answered, I will answer. But before that,
now they have modified their prayer. They are telling me that the bank account should be attached.
I will come, my lord. Even the bank accounts do not come. I am carrying several judgments. Or before that, my lord, kindly allow me only 2 minutes, my lord.
Yes.
Only 2 minutes.
15 minutes.
I'm grateful, my lord.
Give me
My lord,
15
kindly
minutes,
come to section 60, clause 1, subclause M, where, my lord, it has been categorically held that what are the properties which can be attached and which cannot be attached.
Yes.
In section 60, M, my lord, it is categorically stated that any, my lord, may I read out? I'm sorry, my lord, it's taking. An expectancy of succession by surveyorship or other merely contingent or possible right or interest. This, my lord, cannot be attached.
What is it? What is it?
My lord, section 60,
Ah.
clause 1, M, my lord.
M.
M.
Any expectancy of succession or other merely contingent or possible right or interest.
Yes. Now, my lord, my contention is at the time of disclosing the affidavit of assets, the judgment debtor has categorically mentioned that a arbitrator is appointed over that property. Now, my submission is her right over that property. A layman will always say, who is competing in an arbitral tribunal to get something from that, will always say,
the arbitration proceeding is going on in her absence.
Her?
Yes.
She is not the party there, my lord.
Who is
Is some judge, another party, my lord.
Yes.
Then-
Kindly let me finish, my lord. Let me finish thereafter, my lord.
What my learned friend
No,
means
no,
is
no, no.
arbitrator is appointed over the property.
Please, my lord, let me
Arbitrator
finish, my
cannot
lord.
be
I have not
appointed.
interjected her.
Yes.
This way hearing, thank you, my lord. Now, my lord, my humble submission is a property upon which a arbitrator is appointed and the judgment debtor's right over the property is contingent upon the award, a future award which may be passed in her favor. My client
The
may not
arbitration proceeding is between your client and
a joint development. What happened, my lord, in 2013, this property, which my learned friend is claiming that a receiver should be appointed or in a secondary contention is the court should attach directly. In that property, I have submitted the judgment, my lord, already that Honorable Karnataka High Court has appointed a learned arbitrator, A.K. Gopalan, former judge of Honorable Karnataka.
whatever it may be.
My contention is today whether the judgment debtor is claiming her right over that property through this arbitration proceedings. Therefore, the right today the judgment debtor is claiming over the property is a mere contingent right depending upon a future decree, which is a contingent right. I am carrying authority, my lord, which will show that, my lord, law of execution, B.N. Banerjee, which has clearly stated, these are authorities like Mullah, that says that a decree, a future arbitral decree is a mere contingent right. Depending upon that, a property cannot be attached. This is my first submission. Therefore, this question of attaching does not at all arise because today my right over the property, which a layman will always claim, a person who is contesting in arbitration proceedings, will she depose that no, that is not my property? She will always say this is my property, but it is the duty of the court and the learned lawyers to examine that whether that can be attached or not. In my humble submission, the judgment debtor is claiming her right over the property through a award of arbitration that is yet to come. Therefore, that is a future award. And a future award can only give a contingent interest.
Whether in the arbitration proceeding, what is the question involved?
In the arbitration
The
proceedings,
title.
yes, my lord, her allocation. That is the main
That
question.
is so allocation is different. That he needs 107. He is giving 207.
I may
That
fail
is
in
different.
this argument.
But the thing is that whether there is a title dispute. No.
There is, my lord, what happens?
Only
when
allocation.
the property is going to judge joint development. There is the landowner will get some allocation. The person who is building that the contractor will get some allocation. Now that has to be crystallized.
Can I ask the decree holder to intervene the arbitration proceeding?
No, that is my whole case. If that cannot be done, then the right of the judgment debtor is today contingent, my lord.
How the arbitrator will know that this is going on here? That
There is no problem. My
suffering
only
from.
contention is whether this property can be attached in a proceedings of execution where the right is
Okay,
contingent.
so far as the property.
Property.
And so far as the bank account.
I will come, my lord.
Oh.
So far as the bank account, I will show the judgment, and from CPC that a court which do not have the jurisdiction cannot proceed. My lord, kindly come to section 39 straight away, subsection 2, subsection 4, my lord. I'm sorry, subsection 4.
39.
Yes, my lord. Section 39, transfer of decree.
Section 39. Yes.
Yes. My lord, kindly note that this is a subsequent amendment in the year 2000, my lord, 2002. Subsection 4 has been added in the year 2002 by amendment. So, my lord, this is the latest intention of the legislature and this is the law.
What is the law?
Nothing in this section
Where-
shall
where?
be deemed to authorize.
Where?
My lord, subsection 4, section 39.
Nothing in this. Yes.
Nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of its jurisdiction. Therefore, my lord, even if the bank account of the property, if it is outside the jurisdiction, then this court has no jurisdiction to exercise. More so, this is a 2002 amendment. This is, my lord, the latest intention of the legislature. Now, my lord, let me show the judgments one by one, which will show that in case of money as well, is I have a specific judgment which has deals that where the money is payable, that is not the question. Where the money is lying, that is the question at the time of execution. Yes, my lord. First, my lord, before coming to the High Court and Supreme Court judgments, I just show that what is the practice here in Calcutta High Court. Ma'am. Thank you. Because this is the unreported judgment, I have supplied copy to my honorable, my learned friend. My lord.
Yes, 39D.
Yes, my lord, 39D. But my lord, we have to take the latest intention of the legislature. I will show a judgment which has clearly stated.
What is the 39D? What is 39D?
My lord, there was before 2002, there was a confusion regarding this matter.
If the court which passed the decree, considers for any other reason, which it shall record in writing, that the decree should be executed by such other court.
Yes.
Is entirely dependent upon me. If I
I will satisfy. Yes.
This is my
no. Now I will place a Supreme Court judgment which has said that previously, when the 2002 amendment was not there, it could at best said that this is a discretion of the honorable court which is executing a decree. But the legislature by amendment in 2002 has made itself clear that this is, my lord, no more a discretion. This is my humble submission, my lord. This is because otherwise subsection 4 have no effect. Otherwise, if it is a discretion, then why subsection 4? Because, my lord.
No. Nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any property. I am not executing. I am sending it to.
My whole contention is that, my lord, that this court has to send this decree by way of transmission. From the very beginning,
that is the issue. I cannot.
Yes, my lord. I'm not saying that my lord is powerless.
This is the
my lord has ample power.
This is the basic principles.
Yes,
even before the amendment, this is the basic.
Yes,
principle.
my lord. That is my contention.
Okay.
That this
I have to transmit to a such and such court for executing by way of by way of attaching or something like that. Okay.
Yes, my lord has to transmit.
So you have
the decree
agreed.
and that no, but before that, my lord, section 60M. That, my lord, kindly discuss in your order that
that is a property, contingent interest or something like that.
Yes.
But so far as the attachment of bank account.
My lord, if my lord send the decree to the appropriate court, that court will attach. This court cannot proceed in attachment. I am having the judgment. I will place one by one. Now, my lord, I have just submitted a judgment, a order.
Order.
To show that what is the practice here. From bare reading of tabular statement, it is evident that petitioner is entitled to obtain any.
Is not entitled
to obtain any order from this court in respect of the immovable properties situated outside the jurisdiction of this court.
Okay.
Therefore, accordingly, leave was granted, matter was withdrawn. In another matter,
kindly read the entire. It was
Very well.
regarding an arbitral award. Read.
why I am showing arbitral award, I have answered. Let me finish, ma'am.
Read the order.
Accordingly, leave is granted to the petitioner to withdraw this application with liberty to file appropriate application to execute the arbitral award before the court of competent jurisdiction. Very well. This is not a reported judgment. I just showed this honorable court that what is the practice. Now, my lord, I will show reported judgments where it has been clearly stated. My lord, kindly come to. Yes. Lord, this question, whether a court without having jurisdiction can at all proceed or not, has been decided way in the year 1932. Now, my lord, this is the reported judgment of Calcutta High Court.
Privy Council or something.
Horidashi Basu versus National Insurance of Company.
Yes.
Yes. Now, my lord, kindly come to page number 201. My lord, from the middle, may I?
Yes.
From the middle, my lord, I want.
As a pure question of law.
My lord, it has stated the executing court, like the court entertaining a suit, must have territorial jurisdiction over the subject matter against which execution is sought. Where it has no jurisdiction, the provisions of Section 39 Code of Civil Procedure must apply. That is to say, the executing court should send the application for execution to any other court which has such territorial jurisdiction. The word may, my lord, the discretion part, the word may used in Section 39 does not mean that it is in the discretion of the court which passed the decree, either to execute the decree itself or to send the application for execution to another court, where the property against which execution is sought is situated outside the jurisdiction of the court which passed the decree. The discretion given there indicates that the court should send the application for execution to another court which it thinks that the decree is executable in the way payable. Now, my lord, next. My lord, kindly skip the next paragraph. My lord, there is also relevance, but now the money part, whether bank account can be attached or not. May I read out, my lord? If the movable property, now the bank account is a movable property. Supposed, if the movable property such as money.
Where?
Just skipping one paragraph, in page number 202.
If the movable property,
yes, my lord. The movable property such as money against which execution is asked for, it is not within the territorial limits of the executing court. The only other way in which the court may have jurisdiction to execute the decree is when the person against whom execution is sought or resides within the jurisdiction of this court. So, my lord, the judgment debtor does not reside here. So, this part goes next, my lord. Except where these or one of these circumstances exist, the executing court has no jurisdiction to seize property which is not within the territorial jurisdiction, or where the person against whom the execution is sought does not reside within the territorial jurisdiction. Therefore, my lord, in my humble submission, this court, since the judgment debtor is not residing or not carrying on business voluntarily within this honorable court, and my lord, the immovable property part, from the very beginning, I am submitting that I am suffering a decree, whatever means, if the law provides, I have to pay. But in a proper way, as prescribed as per CPC, I cannot go beyond the law. Neither this court, with all respect, go beyond the law. Now, my lord, therefore, my lord, from this judgment, I say that this court should transfer this matter subject to the hurdle of section 60M, that whether this right is a contingent or not, send this decree to the honorable court having proper jurisdiction.
Yes.
And my lord, there is another difficulty. This application is itself is a faulty application. There is technical defect which is not complying with the original side rules. But may I show that?
No, today is time up. Come back on tomorrow.
For your lordship rises, my lord,
Hmm.
with regard to item number 16.
Alcasol.
My lord,
Lordship,
with regard to
tomorrow,
item number 16, my lord.
Just a minute.
tomorrow I have some difficulty, Lordship. Day after tomorrow, your Lordship.
21st.
My lord, item number 16, my lord, there was a talk of settlement going on, my lord. Lordship, will recall, my lord, we have already received the terms of settlement. Lordship may kindly fix it next week, my lord, any date.
16 টা after 1 week করে দিও তো লিস্ট ম্যাটার আফটার 1 week এরকম বলে একটা অর্ডার করে দিও ওকে
Grateful.
বসবেন নাকি? Item number 15.
Lordship, I am appearing on behalf of the decree holder. I am led by Mr. Nirmalo Dasgupta. I think he is online.
লাইন আছে
but I can't hear him. এটা কোনটা গো? এখানেই পড়ে রয়েছে আগেরটা।
বন্ধ করে দিন, আমি বলে দিচ্ছি। Lordship, if you kindly take the last order passed by your Lordship on 2024.
What is the other side?
He was just there. He's waiting outside.
দেখি আগের দিন অর্ডারটা দেখি।
Milord, it's my application, Milord. Milord, this is my Milord.
Judgment data is present.
I have not seen him, Lordship.
Milord,
pass over.
Lordship now, Milord.
Sir, করবো।
পাস ওভার item number 17
Lordship, he is there. Item number 15.
Item number কত?
15 টা করে দাও 15 না
Milord, am I audible now?
I am appearing on behalf of the our debtor, decree debtor, Milord. On the last occasion, if your lordship sees the order of 7th of February,
He has seen it. I have shown
yes, Milord, then we have to file these documents. We had served it to the other side, but we couldn't
No,
file
no,
it.
Milord. As per my instructions, Milord, we have not received any copy.
On previous occasion, on that ground, you sought for an accommodation.
No, I'm referring
Yes.
to the order of 7th of February 2024.
What is that? Please read.
Milord, the learned counsel for the judgment debtor has submitted that though he served copies of documents pursuant to order dated 29 September 2023 to the decree holder, he did not file the same before this court due to inadvertence. He seeks for an accommodation. Let the matter be fixed on 12th.
for examination.
Today I'm holding these
Examination.
documents in my hand. If your lordship kindly permits me.
Yes,
Right.
where is your judgment data?
Milord, he was present on 12th of February. He travels from Gurgaon, Delhi. If your lordship, Milord, kindly fixes a date, and he's a person who is of advanced age in excess of 70 years, Milord. He has appeared before this court.
The file this
Yes, Milord, may I
documents.
be permitted to file?
The
The
copies
copy of the order is enclosed, Milord.
copies have been submitted.
Yes, it was
We have
submitted.
received.
Okay.
He has also been cross-examined on 2 occasions.
Okay.
So he has cooperated with the court. The only difficulty which I now beseech your lordship is that he be given at least 4 weeks time because he has Milord some medical exigencies in Delhi.
No.
was here.
All judgment debtors are
But
suffering.
he was
Yeah, I have seen.
lordship will kindly consider he was here on 12th. It's not that he was not here.
Because
but
I
your
am
lordship
not.
had a division.
I am not there. I was not there. That's
Maybe
why
some
he was there.
We are all cooperating with ourselves. It's not that my
Because I was not there. So judgment.
Milord, am I audible to your lordship?
Neither am I indicating, but we are all cooperating. The judgment debtor has been cooperating. It
No.
cannot be said that he is avoiding.
It cannot be.
No, Milord, this is not
But
a
that's
ground,
my
Milord, to
request to your
seek
lordship.
adjournment for
Lordship
4
will
weeks.
consider.
Weeks.
Milord, this is not a ground to
15
Milord,
days.
kindly issue
Okay.
Milord arrest
The
warrant.
learned
and Milord
counsel for the
exit.
judgment debtor has.
Lordship, then kindly record my submission at least for 4 weeks. Because then my solicitor
Kindly
will at
issue
least
Milord an
notice
arrest
that I
warrant,
have
Milord,
been.
all
Yes.
exigencies will go.
Rest I leave it to.
The learned counsel for the judgment debtor has submitted the documents pursuant to the order dated 29 September 2023. Stop. Copies have already been served. Stop. Let these documents be taken on record. Stop. However, the learned counsel for the judgment debtor has sought for an accommodation for 4 weeks as the judgment debtor is suffering from some certain ailments. Stop.
My lord, I was praying for 1 week. If it
The learned counsel for the decree holder raises strong objection. Stop. List the matter after 15 days.
My lord, will it be your lordship's pleasure kindly to fix a time?
Date.
Because he will be coming from Delhi. My lord, date and time, date your
এই
lordship.
ডেটটা কবে হবে? 4th March at 2 p.m. করে দাও।
May it be on 5th. May it be on 6th, Milord, because I am out of station on 4th and 5th. May it be
6th
on
March at কটায় করবো? দুটো করবো না? যদি কিছু দিয়ে দেয় ওখানে ডিভিশন বেঞ্চ তখন কি হবে?
At 2 o'clock, if your lordship fixes, that would be very convenient.
2 o'clock মিলার
তখন বলবে যে আপনি হবে না,
কিছু বলছি না, মুখ খুলছি না।
12 দিয়ে দাও নাকি 12 noon করে দাও, 12 noon.
The need be at 2 o'clock, Millard.
No, 12 noon.
Well,
Yes, because I have to accompany some honorable judge, senior judge, maybe. I do not know. 12 noon.
Grateful, man.
I'm deep love.
Plus 12
develop.
appearance study.
তো অনেক মিত্র আটকে ছিল।
Item number 17.
For the item number 17, for decree holder, my lord.
16 টা? Yes, আগে হয়ে গেছে না?
26 দিয়ে ওটা সময় তো।
Oh, what? Yes. Yes.
And for the decree holder.
Yes. What is the judgment letter?
Senior Mr. Huda, he is on the way. He's coming. That's it. Not possible. Mr. Probal Mukherjee is leading me, my lord. He is also in Lake, my lord.
Yes.
May it be taken up, my lord, tomorrow, subject to my lord's convenience. Today, আজকে করুন। আজকে 500 করে টাকা না চলছে, 500 করে মামলা চলছে, ওটা শেষ হয়ে গেলে ফিক্স করে নিন।
এই কালকে দুটোর সময় কি আছে? ঠিক আছে, কালকে তো ঝামেলা আছে অনেক। So not today.
I'm grateful.
আর একটা কি আছে? পাসওয়ার্ড আর কি আছে?
Second call, passover matter, item number 7.
For the decree holder, my learned friend was supposed to make his submissions.
Please, your lordship. এই এটার মধ্যে নোট করেছি একটা কিছু।
Oh, এগুলো।
Yes. That I am appearing for the judgment debtor in this matter. Just to give your lordship a brief background of this matter, so far as the suit is concerned. Suit filed for eviction against me. Application under Chapter 13A of the original side rules filed against me for summary disposal on the ground that I have no defense.
Chapter 13.
Chapter 13A of the original side rules, my lord. For paying for summary disposal on the ground that I have no defense. Affidavits filed, matter heard finally, and the court was, my lord, pleased to pass an order of eviction against me, a decree of eviction.
So you entered appearance?
I entered appearance, yes. No written statement was filed, but in my application, in my opposition to the Chapter 13 application, I had said that I have a defense, and therefore I should be allowed to file a written statement. But the court held that no, you do not have a defense, a decree has to be passed against you.
So against that order,
against that order, I filed an appeal. In the appeal, I filed a stay application. In the stay application, I got a conditional stay. Two conditions were given. One is I have to pay the arrear rent for the last 7 or 8 years, which totaled about 1,68,000. And the Honorable Division Bench also held that you will get a stay provided in addition to this 1,68,000, you deposit a sum of rupees 5 lakh with the registrar of this court. I have unfortunately not been able to comply with this order. So today, my lord, there is no stay in operation. The appeal is still pending. The appeal is still running in the list today also, in fact, before the division bench presided over by Justice I.P. Mukherjee. So far as those two payments which I were required to be made, I have not made them. I am today in a position to pay that 1,68,000 so far as the arrear rent is concerned. But so far as the 5 lakh is concerned, I'm being candid, my lord, that I'm not in a position to make this deposit.
And being executing court, I cannot interfere this matter.
Typically, yes, that is the rule. Your lordship cannot go behind the decree. Exactly. But there is one exception to this rule. And that is a very big exception, which has been held repeatedly by the Supreme Court. I am carrying certain judgments. On one of the earlier occasions also, I relied on this judgment to show that I am entitled to take this point in execution. The only exception, my lord, in an execution proceeding is if I am able to convince the court that the decree which was passed without jurisdiction, and as a consequence, the decree is a nullity, then the executing court has no right, no power, no authority to execute the same. That is my main defense in this execution proceeding. That the decree was passed without the court having jurisdiction. Therefore, the decree is a nullity. Therefore, there is no decree in the eye of law. Therefore, this executing court, your lordship, cannot execute this decree. And this point, my lord, I am entitled to take, even though I may have filed an appeal, even though I may have been granted a stay which I have not been able to comply with. Because in an appeal court, my lord, and in this case also, I may have various grounds or various challenges for appeal. Point of challenge so far as jurisdiction is concerned is a very limited ground. And that is the ground, my lord, which I'm urging before your lordship today. My point on jurisdiction, I'll show your lordship the papers, but just to give your lordship a bird's eye view of this matter. On what question I ask myself is, on what ground am I challenging the jurisdiction of the court which passed the decree? My ground is that of pecuniary jurisdiction. The court did not have pecuniary jurisdiction to entertain or adjudicate the suit because the suit was overvalued. The suit ought to have been valued under a particular provision of law under the West Bengal Court Fees Act, but was valued on an entirely different premise, a wrong premise, in order to draw the jurisdiction of this court. Hence, the court did not have pecuniary jurisdiction. Hence, the decree which was passed is a nullity. That is my short point. I will show two sets of judgment to your lordship, my lord, after I finish placing the relevant facts and the relevant pages of the pleadings. One set of judgments will be with regard to the pecuniary jurisdiction.
So if that be so, you can take up the point that the fraud has been committed upon the court. Can it be taken?
Yes.
No.
I have not specifically pleaded fraud because I don't think there was any malified intention or wrongful intention on their part, because they did place all the relevant documents on record. But the court wrongly or erroneously held that it had the jurisdiction, it had the pecuniary jurisdiction, which is why I'm aggrieved in this execution proceeding. This executing court, I agree, cannot go behind the decree. But this executing court is well within its power to see whether the decree was passed with jurisdiction or not. And it's a very simple point, my lord. I'll quickly indicate in one sentence. They have valued, this was a dispute between a landlord and a tenant, as per the case made out by them in the plaint. They have valued the suit on the basis of the market value of the premises. In my humble submission, the suit ought to have been valued under the provisions of Section 12B of the Court Fees Act, which is, my lord, 12 months rent. The last rent which is payable, multiply that into 12 times, and that will be
Court Fees Act.
I beg your lordship's pardon.
Court Fees Act.
Court Fees Act, yes.
Section
12, Section 7, Roman 12, subsection D. 7 within bracket, Roman 12 within bracket D. D for Delhi, my lord. My lord, this is the short crux of my case, my lord. May I first take your lordship to the plaint? That is annexed to my affidavit in opposition. And the plaint starts at page 14 of my affidavit in opposition.
Yes.
My lord will kindly see, my lord, kindly give me a moment. Kindly come to my lord internal page 7 of the plaint or page 24 of my opposition. Paragraph 9 of the plaint. If your lordship has para 9, the said lease dated 21st January 1997 was duly given effect and the same has run its full course. The aforesaid term of 21 years was over on Poshbadi 13 Shamwat year 2072 corresponding to 8th January 2016. So his contention in his plaint that the lease deed via which the defendant was given possession of the suit premises, that has come to an end, and by virtue of efflux of time, I am liable to be evicted. So, my lord, I must point out that it is an admitted position that the lease rent which was payable was monthly rent of 2,000 rupees. That is an admitted position. Now, kindly come to paragraph 13 of the plaint at page 26. Yes. Paragraph 13, my lord, at page 26, 13 of the plaint. I'll just show 2 or 3 more paragraphs on the plaint, and that will be sufficient. Lordship has para 13. The defendant has also failed and or neglected to reply to the said letter dated 5th October 2015 and has refused to vacate the suit premises and hand over vacant and peaceful possession thereof to the plaintiff, though the defendant was bound to vacate the same, since the said lease deed already expired on 8th January 2016 and the lease granted towards the defendant stood terminated by efflux of time. The defendant as such is in wrongful and illegal occupation of the suit premises as trespasser after the lease stood terminated and the defendant has no holding over right in terms of the said lease. Lordship will kindly turn to the next page, para 15. In view of the aforementioned facts and circumstances, the plaintiff is entitled to vacant and peaceful possession of the suit premises from the defendant, and the plaintiff therefore is entitled for a decree of eviction of the defendant from the suit premises. Since it is categorically mentioned in the says lead dated 21st January 1997 that on the expiry of the aforesaid term of the lease, the defendant shall make over quiet and peaceful possession of the suit premises to the plaintiff, whether demanded or not, in the same condition, in default, the defendant shall be treated as a trespasser. The defendant therefore cannot and does not have any defense and or ground by which it can still claim for the said lease to continue and thereby continuing exploiting the said premises without any authority whatsoever. In fact, in terms of the said lease deed, the plaintiff is also entitled to claim a compensation for illegal holding over and or continuation of possession by the defendant after expiry of the scheduled period. Now, my lord will kindly turn over to the next page. Para 17, my lord, he says the same thing. Defendant is wrongfully and illegally continuing to use and enjoy the said premises and has failed and neglected to quit, vacate, and hand over vacant and peaceful possession of the suit property. Despite specific reminder, the defendant has been in and still is in wrongful and illegal possession of the said premises and is occupying the same as a trespasser. So, my lord, his case is very clear, my lord. I entered into the property, or the defendant entered into the property on the basis of a lease deed. Lease deed was for a fixed period. That time period is over. Therefore, I'm a trespasser. Therefore, I should be evicted. That is his case. Now, kindly see the valuation. How has he drawn the court's jurisdiction? Kindly turn over to the next page, my lord, paragraph 21. For the purpose of jurisdiction and court fee, the suit is valued at over rupees 3.57 crores, being the market value of the suit property from where the plaintiff is seeking eviction of the defendant. The plaintiff has therefore paid maximum court fees of rupees 50,000 and undertakes to pay such further or other court fee, if any, as may be directed by this honorable court to pay. So his ground or his case, so far as jurisdiction of this court is concerned, pecuniary jurisdiction, is based entirely on the market value of the premises, 3.57 crore.
And what court fee he has paid?
He's paid the maximum court fees, rupees 50,000. That is the maximum payable. No difficulty there, my lord. But this 3.57 crore being the value of the suit premises is where I join issue. The valuation could not under any circumstance be 3.57 crore. The valuation could at the highest be said to be rupees 24,000. Why so? Because the monthly rent which was payable admittedly was 2,000 rupees per month. 2,000 into 12 is 24,000 rupees. And I'll show the relevant provision from the Court Fees Act. The other ground which he has tried to take, my lord, where I join issue, is that he has alleged that I am a trespasser. My lord, the law is very clear and well settled on this point. A trespasser, my lord, has to be a trespasser from the very beginning itself, from the very inception itself. Here there was a registered deed of lease. So my occupation or my entry into the premises was legal, was lawful, and with the knowledge and acquiescence of the plaintiff. That is an admitted position. Now that the time period has come to an end, I cannot be said to be a trespasser. At the highest, my lord, maybe I can be said to be a tenant in sufferance or a tenant holding over possession. Yes, maybe I'm liable to be evicted, but not because I'm a trespasser. It is because I'm a tenant holding over or a tenant in sufferance because the lease has come to an end by virtue of efflux of time. So the valuation cannot be done on the ground that I'm a trespasser, because I'm not a trespasser. My entry into the premises was lawful. Trespasser is somebody who enters the premises on day one who had no authority to enter the property. That person would be a trespasser. Now, my lord, I will not trouble you with the facts so much because these are admitted facts. Your lordship only has to interpret
the law points only.
Law point. Yes. These are the relevant facts. Kindly, my lord, take the West Bengal Court Fees Act 1970.
Yes.
Well, we'll kindly come to section 7, coming under chapter 3 of this act. Lordship has chapter 3, which deals with computation of fees. And section 7, the heading, my lord, is computation of fees payable in certain suits. Kindly come, my lord, to Roman 12. Or is it Roman 13? Yes, 12 later. Well, perhaps it's Roman 13. There seems to be 2 12s in my pair act. Well, the heading is, my lord, between landlord and tenant.
Just a minute. 13, no?
Lordship has that? Between landlord and tenant?
Yes.
Well, may I place this, my lord? In the following suits between landlord and tenant.
There is a 11 or something like that. 11.
Yes, 11 was to redeem. Then 12, for some strange reason, I have 2 12s in my book, my lord.
In the following suits between landlord and tenant.
Yes, between landlord and tenant. Yes. My lord, I will come under subclause D. 712D says, my lord, in the following suits between landlord and tenant, A is not relevant, but I'll place it nonetheless. For the delivery by a tenant of the counterpart of a lease. B is to enhance the rent of a tenant having a right of occupancy. C is for the delivery by a landlord of a lease. And D, my lord, is the relevant one. For the recovery of immovable property from a tenant, including a tenant holding over after the determination of a tenancy. I am squarely
section
covered
7,
under this.
Section 7 is... এটা কি আমার এটা তো আসছে না তো।
May I hand over my copy, my lord?
এরকম হবে কেন? Court Fees Act 1870.
1970, my lord. Maybe your lordship is looking at the earlier.
এইটা West Bengal Court Fees হবে।
Yes, the West Bengal Court Fees Act 1970.
একটা কপি দিন তার।
West Bengal Court Fees.
Right?
Yes, 13. 12, 12.
Yes, I don't know. That seems to be 2 12s. I don't know if that typographical error is there in your lordship's copy also. But my lord, the heading is between landlord and tenant.
Yes.
in the following suits between landlord and tenant, plaintiff is the landlord, defendant is the tenant. Kindly take D, my lord, which is the relevant one. For the recovery of immovable property, he is trying to recover an immovable property from me, from a tenant, including a tenant holding over after the determination of a tenancy. So I am, my lord, a tenant holding on to the property after the tenancy has come to an end by a flux of time. And kindly see, my lord, how it is to be valued. According to the amount of the rent of the immovable property to which the suit refers, payable for the year next before the date of presenting the plaint. So what is relevant for the purposes of valuation of the suit is the rent, 12 months rent, not the market value of the premises. That is irrelevant. That is not a relevant consideration or a relevant factor at all. So 2,000 per month into 12 months, 24,000, substantially below, my lord, the pecuniary jurisdiction of this honorable court. The city civil court or the small causes court will have jurisdiction in such a case, my lord. Yes. The high court, my lord, the threshold is 10 lakh. So this court, my lord, to begin with, had no jurisdiction.
Were there any prejudices caused to you? What is the prejudice?
The prejudice is in the decree of eviction is passed against me by a court which does not have jurisdiction. That is the prejudice. I am going to be thrown out of the property if today your lordship goes ahead with the execution of this decree.
The procedure in city civil court is different, no? You have to give an opportunity to file written statement.
Correct. To file written statement, etc., etc.
West Bengal Premises Tenancy Act.
There is no equivalent Chapter 13A provision before the city civil court or the small causes court. That is the prejudice.
So it is only law point, but it has
been the law point. Yes,
it has already been decided.
Yes, it has been decided against me, but your lordship also, while executing the decree, has the right to go into this issue. I will satisfy your lordship. I am judgments of the Supreme Court in similar tenancy.
But then I have to act as an appeal court.
No, your lordship will only examine whether the court
appeal is pending. Just
I understand the preference.
Appeal is pending on that point. Now I am deciding
against that point as well as other points.
Yes.
Before your lordship, I can only urge the point of jurisdiction.
Exactly.
I cannot urge other points.
If I say that yes, it is overvalued, the court did not have the jurisdiction.
That's right.
Then what would happen to that appeal? You will withdraw.
That will become infructuous. I don't need to proceed with it.
Whatever it may be, this point was taken at the time of in the trial court.
Yes, it was taken there.
Now, what is the
trial court? I'll show that. I'll show the decree also. The order, the relevant ordering portion also. The trial court held against me on this point. The trial. I'll tell your lordship why it held against me, and that is wrong in my humble submission. The trial court relied on the judgment of the Supreme Court passed, I think, in 1974 or 1976, relied upon by them, which was under the earlier Premises Tenancy Act, 1956 Act. Under the West Bengal Premises Tenancy Act of 1956, market value of the premises was a relevant consideration to decide whether the court had jurisdiction.
Just a minute. You just show that I can decide this issue.
Very well.
Please show the. Otherwise, I shall
yes,
stay the instant execution proceeding till the disposal of the appeal. This is my contention.
Very well.
This is my contention.
Very well.
You show me that even being an executing court can.
Yes. I bow down to
can do that even during the pendency of an appeal on this point.
Right. That's right. Absolutely.
Otherwise, I have to state the execution proceeding and ask you to go with your appeal and come back.
My submission would be your lordship has the power to decide this issue.
Now, show me that judicial decision.
Yes, I'll show 3 decisions, my lord.
Okay.
2 of the Supreme Court and 1 of the Madras High Court, my lord.
Okay.
First, my lord. I'm relying on a judgment passed by the Honorable Supreme Court.
But as that is a stay application, no? Stay was not granted because you did not comply with the conditions.
Yes, stay is there. The order of stay is there, but I have not been able to...
Admission of appeal is not on.
That has been
admitted.
That has been allowed. It's been numbered. It's pending also. It's running in today's list also, perhaps as item 81 or 82.
Okay, show me that. Judicial decisions reported in.
Well, 2019, volume 17, Supreme Court cases, page 82.
Page 82.
Kindly take, my lord,
page 82.
paragraph 17 of this judgment.
Paragraph 17.
CC. Just one paragraph, my lord, from this judgment, para 17. The lordship has that. Yes. We are of the view that it is settled law that if there is an inherent lack of jurisdiction, the plea can be taken up at any stage and also in collateral proceedings. This was held by this court in Kiran Singh versus Chaman Paswan, reported in 1955 Supreme Court cases, my lord. Para 6 of that judgment is quoted by Justice Nariman in this judgment. It is a fundamental principle, well established, that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. A defect of jurisdiction, whether it is pecuniary or territorial, or whether it is in respect of the subject matter of the action, strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of parties. If the question now under consideration fell to be determined only on the application of general principles governing the matter, there can be no doubt that the district court of Munger was quorum non-judice and that its judgment and decree would be nullities. So, my lord, from this judgment, my lord, it is clear, my lord.
This is a peculiar thing. Whether in this cited decision, whether this point was taken at the time of trial, because you have taken the point at trial, that trial court decided. Now you are on that adjudication, appeal is pending. Whether this factual aspect is same.
Check that factual aspect. I've understood what is following from the lordship. But even if that factual aspect is slightly different, my lord, the Supreme Court does not make a distinction.
I am not proceeding with the execution proceeding. What I am saying, I shall stay the matter. I shall ask you to go for disposal of appeal. Come back with.
Well, my lord, I can do that, my lord. No difficulty there.
Otherwise, it cannot be. This is my.
I can do that.
Okay. Anything? Otherwise, very serious issue is brought to my notice.
Because your lordship, if your lordship feels that the suit has been overvalued, and if the appeal court feels otherwise,
has been brought, but the trial court has decided on this point, and on this point, appeal is pending.
Correct.
Now, I cannot take the function of appeal court.
I appreciate what is following.
Okay. Come.
Would your lordship just pass it over for a while? My senior is on his.
Who is your senior?
Mr. Dashgupta, who was appearing on the last
I've
occasion.
forgotten his rules. Whatever it will, take instruction.
Or just grants me a day's time.
Anything else to submit?
If this is the view your lordship is taking, my lord, then I have nothing further to submit. If
You
the
would just
lordship
like
wants
to
me to hear,
have a word with the
matter on
client,
that
because the decree holder, we would just like to have a word with the decree holder also. Then keeps it tomorrow. We shall come back with instructions, whatever falls.
No, you are quite efficient. I have found that on
I am led by.
previous occasion. Now, just academic discussion.
Yes,
Please,
your lordship.
discuss.
Your lordship, whatever has fallen from your lordship, that I bow down to it. If your lordship feels that the suit has indeed been overvalued, and if the appeal court feels that that is not so, then it would be a peculiar situation indeed.
Yes.
Or vice versa.
Okay.
It would be a peculiar situation.
So I am not dismissing the execution proceeding right now.
I understand.
Let it
Because
be
they have
pending.
taken this point before the learned trial court, and the trial court has returned the finding.
Yes. That's why, and on that point,
there's an appeal also.
Yes, there is an appeal.
So I cannot reserve.
Yes, so perhaps very respectfully, your lordship sitting singly perhaps cannot alter that finding.
Exactly. That is why you have understood.
I have understood.
At least you have understood.
I have.
Clever.
I have.
Okay. Tomorrow?
Well, can it be Thursday, my lord?
Yes, no problem.
Thursday?
Thursday, I have a different bench after 2 p.m.
This will be heard in the first half?
Yes, first half. Okay. Just 2 or 3 minutes time will be, whether yes or not.
Yes.
Otherwise, I shall pass necessary order.
Absolutely.
I shall pass this order.
Absolutely, your lordship.
Take
I
it
have
for
understood.
granted.
If it can be kept towards the top, then it will be heard
Very well,
before your
very well.
lordship.
এটা টপে রেখে
we-
দিও তো কবে হচ্ছে এটা 22 তারিখ না
22
21
তারিখ।
হ্যাঁ 22 তারিখ হলে টপে রাখো
22 তারিখ, 22nd February is popularly known as Thinking Day.
Thinking Day.
I'll tell you, I was in Boy Scouts when I was in school, which is the American Boy Scouts. So the founder was Lord Baden-Powell, and 22nd February was his birthday. So after him, it was proclaimed to be Thinking Day.
Okay, think about this and come back. On 20. Okay, the learned counsel for the parties have submitted. No, the learned counsel for the judgment debtor has submitted. Has made his submission in respect of the non-executability of the decree passed by the trial court. Stop. Para. It appears that serious points of law was urged by him. Stop. Para. The learned counsel for the decree holder has sought for an accommodation as his senior is not available.
Lordship kindly makes it that to take appropriate instructions. Kindly makes it has sought an accommodation to take appropriate instructions.
Okay, the last line. The learned counsel for the decree holder has sought for an accommodation for coming back with proper instruction.
Yes, Your Lordship.
Stop. Please the matter on 22nd. Topic মোটামুটি topic করে দাও। Okay. এটা রেখে দাও।
And Lordship, may I just get back the copy of the Court Fees Act?
কোনটা?
This Court Fees Act I had borrowed for your Lordship's producer.
No.
With your
You are the all the it is a noble profession.
Grateful.
Okay.
Grateful, Your Lord.
Grateful, my lord.
দিয়ে দাও স্যার নোটটা রেখে দাও।
হ্যাঁ
Is rising now. I don't see anybody in court. That's why I was waiting.
আর কিছু নেই বোধহয়। এই আর কিছু আছে?
হ্যাঁ আইটেম নাম্বার 13
নেই। নোট টুডে করে দাও নাকি?
My lord, I appear on behalf of the decree holder in item number 13.
হ্যাঁ ঠিক আছে